the first international conference on human rights. Excellencies, ladies and gentlemen, before we start our agenda for today, let's sing together the national anthem of Indonesia Raya. Ladies and gentlemen, please stand up. Let's move to the next agenda. They will be reciting the Holy Quran from the Faculty of Da'wah and Communication, who will be recited by Miss Aziza Lutfia Sham. Please, time is yours.
السلام عليكم ورحمة الله وبركاته.
Waalaikumsalam warahmatullahi wabarakatuh.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. ولله ملك السماوات والأرض والله على كل شيء قدير. إن في خلق السماوات والأرض واختلاف الليل والنهار Sadaqallahul azim. Assalamualaikum warahmatullahi wabarakatuh.
Dear audience, ladies and gentlemen, step on following agenda are speeches. The first is welcoming speech from Mr. Dr. Rahman Shamsuddin SHMH as a head of law department. Please, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua.
Waalaikumsalam warahmatullahi wabarakatuh.
wabarakatuh.
Good morning, ladies and gentlemen. Praise our gratitude to God Almighty, thanks to His grace and guidance, so that we can gather together today, online and offline, in this event of the first international conference on human rights organized by the Law Department of the Fakultas Syariah and Hukum UIN Alauddin Makassar. Dear Honorable Rector of UIN Alauddin Makassar, Prof. Dr. Haji Hamdan Johannes, PhD, Honorable Dean of the Faculty of Sharia and Law, UIN Alauddin Makassar, Dr. Haji Muhammad Bakri, LC, MAG, respected speaker, Mr. Ahmad Topan Damanik, Prof. Dr. Haji Nadir Hosen, LLM, MA, PhD, Dr. Megan Campbell, LLM, Dr. Sebastian Spritra, BA, LLM, Supriyansa, SHMH, Dr. Samsudin Rajab, SHMH. Respected presenters, participants, moderators, reviewers, and committee. Introduce me, Dr. Rahman Samsudi, who is also the head of Law Department, the Faculty of Sharia and Law UIN Alauddin Makassar, is very happy because of the presence of all of you in the first international conference on human rights today. As for the things we want to report are, first, speaker in this international conference consists of 4 countries. First, from Dr. Haji Nadir Hussain, LLMA, PhD from Australia, Monash University. Second, Megan Campbell from England. Third, Dr. Sebastian Spritra from Australia. Fourth, Mr. Supriyansa and Samsudin Rajab from Indonesia. And Mr. Ahmad Topan Damanik, who acts as a speaker, keynote speaker, who is also the head of the National of Human Rights Indonesia. Second, the number of the participants in this conference is 44 teams. Consists of academics, practitioners, and we are from Sumatera, Java, Sulawesi, Kalimantan, and also from other country, Timor Leste. So the number of participants consists of the UIN Alauddin academic community as well as from university and other institute from inside and outside Makassar. We hope that this international seminar can run successfully, and for the current pandemic situation will not be an obstacle for us to able to exchange ideas and spread ideas in all methods, especially related to the topic of human rights during the coronavirus disease area. This is the end report from me, head of the law study program of the Faculty of Sharia and Law UIN Alauddin Makassar. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Excellencies, ladies and gentlemen, the second speech will be delivered by Dean of Sharia and Law Faculty, Mr. Dr. Ammar Muhammad Bakri LCMAG. Please, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning,
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Mr. Rector of UIN Alauddin Makassar, the honorable speakers, and also to all participants who I am proud of. Alhamdulillah, wassalatu wassalamu ala rasulillah wa ala alihi wa sahbihi ajma'in, amma ba'du. As the Dean, I would like to welcome the speakers and participants in the international conference organized by Faculty of Sharia and Law, UIN Alauddin Makassar. I really appreciate this activity. This activity carries the theme of human rights in all aspects of life. I feel that this theme needs to be continuously discussed by academic, community leaders, and all parties. The aim is to find the main value in matters that are fundamental to human life. This theme becomes increasingly important when referring to our different backgrounds as human, such as differences in religion, culture, custom, and others. Throughout this discussion, we are able to find common ground on universal values that are accepted by all human beings. For example, in the Islamic teaching, there is a concept known as Maqasid Sharia. The concept is a rule for a Muslim to keep the 5 main things. Among them is the obligation to maintain religion, soul, mind, dignity, and property. The obligation to maintain these 5 things, as well as an effort to maintain basic human rights in life. Allah subhanahu wa ta'ala explained in the Quran that there is no compulsion in religion, including choosing a particular religion. In the Quran, we are prohibited from insulting others, people's God. Allah say, وَلَا تَسُبُّوا الَّذِينَ يَدَعُونَ مِن دُونِ اللَّهِ فَيَسُبُّوا اللَّهَ عَدْوًا بِغَيْرِ عِلْمٍ. Revile not those whom they invoke beside Allah. If a person insults someone because of his religion, then there must be no harmony in the life between religious communities. On other hand, as human, we have the right to life, so it is obligatory for us as human to protect it. Therefore, it is haram for someone to sacrifice a person's life. Allah stated in the Quran, "Man qatala nafsan bighayri nafsin aw fasadin fil ardi faka'annama qatala an-nasa jami'a." Whoever takes a life unless as a punishment for murder or mischief in the land, it will be as if they killed all of humanity. And whoever saved a life, it will be as if they saved all humanity. Islam strongly condemns in the act of sacrificing the lives of others. Therefore, Islam affirms qisas as sanction for killing. The regulation aims as preventive measure against the crime of murder. Likewise, the commandment related to maintain human intellect. In this context, everyone has the right to have the widest possible access to sources of knowledge. The government is obligated to prepare facilities and infrastructure for its citizens in order to obtain a proper education. Women must ensure common sense as a means of control in their lives. Thus, it is obligatory for women to protect it by avoiding drugs or alcohol. The fourth point of the Maqasid Sharia is to maintain human dignity. Human beings are privileged beings from God. Allah say, وَلَقَدْ كَرَّمْنَا بَنِي آدَمَ وَحَمَلْنَاهُمْ فِي الْبَرِّ وَالْبَحْرِ. God doesn't declare that we glorify Muslim, but God glorifies for all human beings, Adam's children and grandchildren, without exception. It is also found in the last speech of the Prophet when Hujjatul Wada, that your dignity is maintained until you face your Lord. Respect others if you want to be honored. The last point of the Maqasid Sharia is safeguarding wealth. Everyone has the right to own property. This includes human rights guaranteed in religion. Thus, people who damage and interfere with the ownership of others, according to our religion, will be given a strong sanction. Islam recommends that property must be obtained by lawful means, not by manipulating. Sayyidati sadati anisati al-aizza. Natakallamu al-an anil huquqil insaniyah. Ajaban li indana fil Islam lianna al-huquq aslul kalima minal haq. Jadi sesuatu yang luar biasa, hak-hak manusia itu dari istilahnya saja berasal dari kata hak. Hak itu adalah ismun min asma'illahil husna. Itu dari sekian banyak nama Allah. Terdapat di dalamnya nama Al-Haq. Jadi sesungguhnya ketika membahas hak-hak manusia, tentu bagi Islam hak manusia itu didasari pada nilai-nilai Rabbaniyah, ketuhanan. Karena itu bagian dari nama Allah Subhanahu wa Ta'ala. Hunaka umur kathirah anil hukuk. Dalam Islam itu banyak hak-hak yang sungguh mendapatkan perhatian. Dalam Al-Quran misalnya terdapat hakul hurriyah, hak kebebasan, hurriyatut ta'bir, kebebasan berpendapat, hurriyatut ta'lim, kebebasan menuntut ilmu, hakut tamalluki wat tasarruf, hak untuk memiliki harta, memiliki hal-hal yang pantas untuk kita miliki dalam kehidupan kita di dunia ini. Hakut tasarruf, hak untuk melakukan karya dan cipta. Hakul amal, hak untuk bekerja. Dan banyak lagi hak-hak, termasuk hak untuk ar-raha, hak untuk istirahat, hakku fil ajri al-adil, hak untuk mendapatkan yang wajar bagi apa yang kita kerjakan. Dan banyak hak yang sesungguhnya merupakan anugerah Allah Subhanahu wa Ta'ala. Karena itu selama hak itu tidak bertentangan dengan nilai-nilai kemanusiaan, maka selama itu Islam mengakomodirnya. Inilah nilai universalitas dari hukum Islam, dari syariah. Artinya Al-aslu fil asya' libahah illa ma yadullu dalil ala tahrimi. Konsep apapun itu selama tidak bertentangan dengan syariah, selama tidak bertentangan dengan hal-hal yang prinsipil dalam Islam, maka tentu itu dibolehkan dalam agama kita. Saya mengucapkan banyak terima kasih kepada saudara yang menginisiasi acara ini dari Prodi Ilmu Hukum dan kepada seluruh pembicara, pemateri, dan seluruh peserta yang hadir pada kesempatan ini. Semoga kita bisa mendapatkan manfaat. I hope that we will get a lot of benefit from this international conference. Besides getting information and knowledge related to our discussing them, I hope it will be the beginning of our friendship with the aim to build better relation among us and in particular the relationship between institutions, insyaAllah. Terima kasih. Bapak Rektor berkenan untuk membuka acara ini. Assalamualaikum warahmatullahi wabarakatuh.
Excellencies, ladies and gentlemen, it's our honors to have the Rector of Universitas Islam Negeri Alauddin Makassar, Mr. Professor Haji Hamdan Johannes, MA PhD, that will be represented by Dr. Kamaluddin Abu Nawas, MAJ, to deliver a speech, and afterward, we would like to request to officially open the first international conference on human rights. Please, time is yours.
Halo, bismillahirrahmanirrahim. Halo.
Ya.
Baik. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Warahmatullahi wabarakatuh.
Alhamdulillah rabbil alamin wa bihi nasta'in ala umuri dunya waddin. Shallallahu salam ala asyrafil anbiya wal mursalin sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Amma ba'd. Yang saya hormati para pembicara ya. Pak Dekan, teman-teman semua dari Sivitas Akademika khususnya di Fakultas Hukum dan Fakultas Syariah dan Hukum. Saya tiba-tiba diminta untuk mewakili Pak Rektor ya. Saya sementara rapat ini, tapi tidak apa-apa. Dan tentu wakili Pak Rektor sangat mengapresiasi kegiatan ini, khususnya kegiatan seminar internasional pada masa pandemi, yang oleh panitia memberi judul dengan The Action and Enforcement on Human Rights in the COVID-19 Pandemic Period. Saya kira ini memang sangat penting karena dalam masa pandemi sekarang begitu banyak persoalan yang kita hadapi yang tidak sesuai dengan apa yang pernah kita hadapi sebelum pandemi. Di dalam Islam tentu kegiatan apapun itu harus tetap berlangsung. Ya, kenapa? Karena kegiatan kemanusiaan juga tidak boleh berhenti karena ada satu virus yang terjadi. Tentu sebagai mewakili Pak Rektor sangat memberi apresiasi kepada teman-teman di berbagai jurusan untuk melakukan hal yang sama. Apalagi kegiatan seperti ini adalah kegiatan akademik yang sangat penting, yang tentu kalau kita berbicara masalah berbicara masalah pembiayaannya tidak terlalu mahal karena bisa mendatangkan pembicara bahkan dari berbagai negara seperti yang dilakukan hari ini tanpa membuang biaya yang banyak. Tentu diminta kepada seluruh program studi, seluruh jurusan untuk berpikir bagaimana senantiasa melakukan satu kegiatan akademik yang sangat penting. Di kita kan ada lebih 50 konsentrasi, ada lebih 50 jurusan prodi yang sebenarnya dengan sangat mudah bisa melakukan kegiatan yang sama. Apa yang dilakukan oleh jurusan hukum hari ini adalah contoh yang terbaik kolaborasi tentu dengan pihak pimpinan fakultas supaya bisa melakukan kegiatan-kegiatan yang sama. Di Fakultas Syariah dan Hukum ada sekian banyak jurusan yang tentu bisa melakukan kegiatan yang sama. Terutama jurusan-jurusan yang baru seperti ilmu falak. Supaya ini lebih dikenal, maka tentu sangat diharapkan untuk melakukan kegiatan internasional, kegiatan ilmiah internasional yang sifatnya internasional. Apalagi seperti jurusan falak ini di Indonesia saja itu masih sangat langka. Saya teringat ketika akan diberikan beasiswa kepada para dosen yang mengampu mata kuliah ilmu falak itu sangat susah. Bahkan pendaftarnya dibuka dengan secara luas, pendaftarnya sangat sedikit. Kenapa sangat sedikit? Karena yang menggeluti bidang falak di berbagai perguruan tinggi keagamaan Islam itu sangat terbatas. Tentu berbeda dengan fakultas atau jurusan hukum. Apalagi jurusan hukum ini bukan hanya di PTKIN, bahkan sudah jauh berkembang, jauh sudah maju di berbagai perguruan tinggi maju di Indonesia khususnya dan tentu di berbagai belahan dunia umumnya. Wakil Rektor tentu sangat berterima kasih kepada beberapa pembicara dari luar. Ya, di antaranya ini yang sering berkontribusi ya di berbagai kegiatan. Maaf, saya melihat ini ada Profesor Nadir Shah Hussein dari Australia. شكرا جزيلا لحضوركم في هذه المحاضرة العلمية يا أستاذ الدكتور نادر شاه حسين من أحد الجامعة في أستراليا. And then Mrs. Megan Campbell from England, and Sebastian Spitra, I can say from England maybe. And then the Dean of Fakultas Syariah, Mr. Muhammad Muammar Bakri, and Shahruddin Rajab, the speakers from this discussion. And then Mr. Supriyansyah, ini salah satu tokoh terkenal saya kira di Indonesia. Kebetulan beliau ini adalah seorang putra Sulawesi Selatan yang saya kira sangat bagus juga ketika dia menjadi seorang speaker atau pembicara dalam kesempatan ini. Maaf, saya baru juga melihat ini Pak Profesor Ahmad Taufan Damanik ya. Ini mungkin dari Indonesia juga. Maaf saya tidak bisa membaca dengan baik. Sebagai pimpinan saya mengucapkan selamat pelaksanaan seminar internasional yang dilakukan oleh kawan-kawan di Fakultas Syariah. Sekali lagi tentu saya memberikan apresiasi yang sangat tinggi kepada teman-teman semua, khususnya di Fakultas Syariah yang bisa melaksanakan kegiatan internasional. Tentu kita harapkan ada feedback, ada implementasi dari kegiatan seminar ini. Saya kira itu yang bisa saya sampaikan. Mewakili Pak Rektor, mudah-mudahan seminar kita ini bisa berjalan dengan baik seperti yang kita harapkan bersama. Syukran jazilan li hudurikum fi hadhil muhadharah al-ilmiyah al-alamiyah wa bil akhas al-mutakallimun minal ajanib al-mawjuda fi hadhil muhadharah. Assalamualaikum warahmatullahi wabarakatuh.
Well, ladies and gentlemen, now we will start our session on the first International Conference on Human Rights. Without further ado, we would like to welcome the first speaker to deliver the material. And to lead the next session, I would like to invite Mr. Muhammad Ikram Nurfuadi to moderate the conference today. I am Nurul Hulwanita Sarpina, would like to say thanks to you all. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. Welcome to the first International Conference on Human Rights 2021 held by Law Department, Faculty of Sharia and Law, Universitas Islam Negeri Alauddin, Makassar. My name is Muhammad Ikram Nurfuadi, lecturer in Law Department, and then I will be a moderator in this panel session. Okay, as we know that the human right is a global issue, so it means that every state and every government in the world have to cover the human right. But how about in this COVID-19 pandemic period? It is the challenges for the world and everyone in the world. I think like that. So the committee has raised the theme, the enforcement and protection of human rights in the pandemic COVID-19 period. So I think it will be really interesting to discuss about it. And before we start, let me introduce the great speakers today. We have several great speakers from 4 different countries. There are 2 keynote speakers. First is Mr. Ahmad Taufan Damanik as the head of National Commission of Human Rights of Indonesia. And then Prof. Nadir Shah Hussain from Monash University, Australia. The other speaker for today is Dr. Megan Campbell, LLM, from Birmingham University. And the second is Dr. Sebastian Spitra, BA, LLM. So the event consisting 2 days. So for tomorrow, the speaker is Dr. Muammar Bakri LCMAG, Supriyansa SHMH, and then Dr. Syamsuddin Rajab SHMH. So, and then for the participants, I, as moderator today, tell the participant, if you have any question while the presentation begin, you can write it down in the chat box of application Zoom. Yes, you can write your question. If you prefer to use Bahasa Indonesia, you can write your question with Bahasa Indonesia, and then I will translate it and then deliver to the speakers, so the speakers can answer your question. Then, yeah, I think it's the time. We can, for the first chance, for Mr. Ahmad Taufan Damanik, the head of National Commission of Human Rights of Indonesia. But before that, I will read some biography of him. Now, Mr. Ahmad Taufan Damanik is the head of National Commission of Human Rights, Republic of Indonesia since 2017. He completed master study at Access University in 2015. Some of the awards that have been won by him are: first, favorite lecturer in political science, North Sumatra University in 2010. Second is award from the governor of North Sumatra, 2010. And the last and the greatest award is Humanitarian Exemplary Human Rights and Peace Building during Aceh in Conflict and Situation in framework of the 10th anniversary in Aceh Peace Forum 2010. I think that's all from him. Let's for Mr. Ahmad Taufan Damanik. The floor is yours. Thank you.
Thank you very much. Is it my voice clear? Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I'm really honored to be invited as a speaker to this international conference of human rights organized by UIN Makassar. Thank you for Honorable Rector, Dean, and also the chair of organizing committee of this conference. I also would like to say thank you to my colleague, Professor Nadir Shah Hussain, Ms. Mega Campbell, Sebastian Spitra, and my colleague also from Commission number 3 of the Indonesian Parliament, Mr. Supriyansa, Mr. Muhammad Bakri, and Mr. Syamsuddin Rajab. In this session, I would like to overview and highlight the development of the idea of human rights in Indonesia, and hopefully another speakers will deeply will discuss on the COVID-19 situation. But I, as a chair of the Human Rights Commission, would like to highlight the in general term of human rights. Let me start from my presentation. Everybody discusses the idea of human rights, and some people think that this is implanted from Western value. But I would say another idea, another opinion on that. According to me, the idea of human rights is basically not a new concept existed. In the beginning of 20th century, along with the existence of national movement in Indonesia, I mean in Nusantara, the founders had discussed this and struggled for rights to freedom, equality, justice, political as well as social and economic rights. Means that the idea of humans already known, discussed, and also struggled by Indonesian. They even succeed to mix up the idea of Islam and Western value. This is the success story of Indonesia. Mixing up the idea of Islam and Western value about democracy, human rights, to against discriminations, colonialism, exploitation, etc. Finally, they agreed to establish a nation state of Indonesia with the principle of democracy and also the principle of human rights. This is the benefit of Indonesia. After Indonesian independence, the debate of constitutional in terms of Indonesian Constitution of 1945 or Indonesian Constitutions 1950 also discuss the modern political thought, modern concept of state, and of course the idea of human rights. Some were referring to the Universal Declaration of Human Rights and Covenant Civil and Political Rights and Covenant of Economic and Social and Cultural Rights. So it means that the idea that's already discussed and struggled at global atmosphere, it is also discussed in our national atmosphere. Proclamation of independence is meant as a commitment to against all human rights violation, respect to the rights of individual freedom related to expression, religion, cultural identity. We know about the Bhinneka Tunggal Ika principle and other civil and political rights as well as economic rights in concept of equality, non-discrimination, and others. It's also a commitment for global peace. In our Mukaddimah of Constitution 1945, we also have a commitment to struggle for a global peace. Means that we are a part of global atmosphere. But it is interrupted by internal political ideological conflict and create a tragedy of 1965, where a million people were killed, detained, tortured, and facing other violence without any judiciary mechanism. Under the authoritarian military regime, since 1967, all democratic processes and the idea of human rights were cancelled. Dictator government controlled all aspects of politics, economic, social, and culture by using military, bureaucracy, and even social and religious organization. Human rights violations become a widespread phenomenon in Indonesia. But in 1993, government realized the importance of an independent state commission to deal human rights as the critical partners of the state. It is to respond to international pressure on esteem of issue and other relevant issue on the situation of human rights in Indonesia. At the time, Komnas HAM was the only institution which became center and hope for justice for the community whose rights being violated. Komnas HAM exists within centralistic government system and Suharto-centered power. However, Komnas HAM at the time has been proved itself as an institution capable to carry out mandate to promote and to protect human rights. In the era of reformation started on May 21st of 1998, when the President Suharto stepped down from the position he had for 32 years, Komnas HAM enjoys the fresh air and democratic atmosphere that never existed in the era of New Order. After President B.J. Habibie replaced Suharto as the president, the law number 39, year 1999 on human rights was issued. It is, of course, strengthened the position of Komnas HAM and also the mandate of Komnas HAM. With this law, Komnas HAM has institutional legality and more firm authority as for both legal and administrative from the Secretary General. The authority of Komnas HAM is also broader, with the issued law on human rights trial under National Law number 26, 2000, which provides Komnas HAM the authority as the investigator for the gross violation of human rights. Now, the situation of human rights violations regarding to the reported cases, complaint of Komnas HAM last year. Yeah. Complaint or reported cases received. This is around 1,792. We see there are a red zone. Yeah, it is not Sumatra, my province, and also from Jakarta, West Java, Central Java, and also East Java. We see Sulawesi Selatan, South Sulawesi. There are quite big cases reported to Komnas HAM, 82 last year. And of course, another provinces, especially from East Indonesia, also reported cases come to Komnas HAM. Types of reported cases based on region. Yeah. In Jakarta, it is about labor conflict, improper law enforcement, especially from the police, and conflict, eviction, or relocation. From North Sumatra, improper law enforcement, mostly coming from the police also. Land conflict, eviction, relocations, including from the BUMN, from the state-owned corporations. Let's say plantations, corporations, government plantation. Improper law enforcement. And then West Java, land conflict also. Improper law enforcement, labor conflict. East Java, improper law enforcement, land conflict, eviction, complaint on judiciary process. So if we see all these types of reported cases based on region, I think this is mostly about access to justice, about labor issue, about land conflict or agrarian conflict, and other issue on administrative governments. Yeah. Classification of victims. Individual, mostly are individuals. Some is reported by Kantor Advokat or LBH, legal aid institutions, also from organization or NGOs, from groups, religious group, adat groups, and there are around 60 cases. We have no information who reported that case. And from individual, we can see the details. Individual, labor, women, prisoner, even prisoner, foreigner. There are 3 cases: detainee, children, LGBT, victims of gross violation of human rights. From groups, it's community groups, labor union, indigenous groups, religious group, LGBT organization, and of course, prisoner group. Perpetrator, yeah. Mostly, I mean, the first is police. There are 534 cases. It is about improper law enforcement. And then some are violences, intimidation, or torture. So we can see that most of the cases who reported about police to Komnas HAM is about improper law enforcement. Means that there are another perpetrator, direct perpetrator, but when they bring the case to the police, there is an issue of improper law enforcement. And then the second is corporations, land conflict, labor issue, and also about the environment. And The third is local governments. It is the issue of land conflict, government workers, government administrations. Classification of rights, right of welfare, access to justice, right of security, right to life, until right not to be discriminated. And the right side, main reported cases based on type of rights, rights of welfare. It is about land conflict, labor conflict, administration, access to justice, as I said, and the right of security, where people think that they got violent torture, improper law enforcement, threat of individual security and settlement. Now, I would like to discuss about the issue of the gross violation of human rights. There are, now we have 12 cases that have been discussing with General Attorney and also under the supervision of the President of Indonesia and coordinating Ministry of Law and Security. Under the law number 26 year 2000 on Human Rights Code, it gives mandate to Komnas HAM to do pro justicia investigation of gross violation of human rights. From 15 cases that have been submitted by Komnas HAM to General Attorney, only 3 cases had been brought to the court. They are Timur case 1919, Tanjung Priok case 1984. I mean the cases happened in 1984, and Abepura case in Papua. All accused perpetrators decided not guilty by judges. Then we have still 12 cases of gross violation of human rights. Those are not brought to the court until now. That's a tragedy 1965-66, mysterious killing 1982-85, Talangsari case 1989, Trisakti Semanggi 1 and Semanggi 2, 1998-1999, May riot 1998, forced disappearance of activists 1997, 1998, Washor and Wamena in Papua, killing of Dukun Santet in East Java, Simpang Kakak case in Aceh, Jambu Kepok in Aceh, Rumah Gedong in Aceh. This is a very famous issue, famous case, I mean, Rumah Gedong. There are so many people died or tortured. And the last one is Paniai, Papua, 2040. This is happened during the first period of President Jokowi. The obstacles that we found is the political will from the government, General Attorney. Non-judicial mechanism as an alternative has not formed yet. Before we have KKR national law, but already cancelled by the Constitution Code. And the third is President commitment to solve the problems. Even though in the last 2 years, there is a very clear commitment from the President declared not only to Komnas HAM when we have meetings, but also to the public through the state statement in front of the Parliament. So now we are discussing the continuous activities to solve the problem of 12 cases of gross violation of human rights. The settlement of past gross human rights violation that I already said to have connection with the state government agencies, including connecting Minister of Political Justice and Security Affairs, to the Attorney General Attorney, to the National Police, and also Armed Forces Commander and Chief of National Agency, Intelligence Agency. All these parties are very important for Komnas HAM to be coordinated with them. And then dissemination to the victims, religious figures, public figure, and also civil society, because sometimes there is a controversy on the issue, especially the tragedy of 1965 and 66. And the last, the preparation of gross human rights violation settlement to judicial and non-judicial mechanism. we as a National Commission propose judicial and non-judicial mechanism. The second issue, we refer to the data, statistical data that I already presented. There's the issue of agrarian conflict. There are so many cases come to Komnas HAM. According to our analysis, structural agrarian conflicts which are rooted on politics and agrarian policies created concentration of ownership, control, usage, and land and natural resources exploitation on one side. And of course, on the other side, more people lost their rights or access to land, natural resources, living space. Therefore, as social phenomena, the agrarian conflict which commonly occurs in the sign of need to reform the current agrarian structure, because the agrarian conflict occurred is the reaction of the community towards the injustice of land control regime within the community. Structural agrarian conflict is a long dispute about a claim over a piece of land, natural resources, and community properties between the community and giant corporation of infrastructures, production, extraction, and conservation. And the disputing parties make direct and indirect attempt to eliminate others' claim. The agrarian conflict means here occurs as the result of permission or right providing by the public official, including the Ministry of Forestry, Energy and Mineral Natural Resources, the head of PPN, governor, and sometimes Bupati or Wali Kota also, who included land, natural resources, and community properties into projects, concession of giant corporation or infrastructure, production, extraction, and even conservation without any proper consultation with the people. The third issue that we think this is also our priority issue of human rights since last year is intolerance, extremism, and radicalism. I hope Professor Nadir Shah will present it more detail after this. Indonesia, of course, as we know, is social culturally diverse, very diverse, and the diversity perceived as an asset and at the same time as a challenge. There are serious challenges, particularly after series of action with violence, extremism, and intolerance perspective toward racial, ethnic, and religion minorities. I mean, a group of religious minorities. There are several laws and policies which legitimizing state discrimination and violence, including local regulation. The ineffective role of the law enforcement apparatus resulted to the growing of vigilante groups. There is a need to develop strategic program which lead to prevent any violence based on socio-cultural pluralism. It is important to support law enforcement institution to become more responsive and effective to prevent and resolve any conflict occur. There is a progress of recent decision of the Constitutional Code number 97 PUU 14/2006, which affirm the rights to devotees of faith outside the country's officially recognized religion. The government obligated to implement the Constitutional Code, including revision some of relevant regulations. Those problems are challenges require new and comprehensive approaches, which may result to enabling environment for a more harmonious society, both at local, regional, and also national level. Komnas HAM recognized serious challenges, particularly after series of action with violence, extremism, and intolerance, perspective toward racial, ethnic, and religious minorities. Komnas HAM also identified several laws and policies which legitimizing state, as I said before, the discrimination and violence. Komnas HAM identified the impact of the problem to human rights condition, the need to understand the cause of problem, and the need to develop strategic program which lead to prevent any violence based on socio-cultural pluralism. Komnas HAM realized the importance to support law enforcement institutions to become more responsive and effective to prevent and resolve any conflict occur. And the last but not least, this is the Papua issue, various forms of injustice. We have already special autonomous status of Papua province and West Papua province designed to address some of the basic issues. The special autonomous status equipped with additional state budget to help the local government in addressing some of the problems. However, right to education and right to health remain major issues. The death of 70 Papuan in Asmat district a few years ago, within the last 4 months, due to malnutrition and measles outbreaks, shows the poor health condition in some of the remote areas. Another issue, of course, is about the violence, not only from our security apparatus, Indonesian Army and Police, but also from the Freedom Papua organization. So our last proposal to Indonesian President Mr. Jokowi is to how to stop the violence in Papua by reviewing the security approach that already have been done many years. And the second is to promote humanitarian dialogue to all parties, to all elements in Papua. These two proposals coming from Komnas HAM, we believe that it can help to increase the much more better condition in Papua, including especially or particularly in human rights condition. I think this is more or less the condition of human rights. Yeah, even though on the other side we also have many progresses. According to our colleague in ASEAN, for instance, Indonesia is still a champion of democracy and human rights in our region. At international level, Indonesian also trusted and also honored because some progress is already done. Now we are a member of Human Rights Council. It is proven that progress of human rights in Indonesia is accepted and also respected also by international. But on the other side, we have so many cases, so many issues that we have to solve, including some priority issues that already highlighted by me. I think this is more or less highlight situation of human rights in Indonesia, and I hope this international conference hosted by UIN Makassar can discuss in more detail specific issue on human rights, including the issue of Islam and human rights, Islam and democracy principles. Thank you very much. I am really sorry because after this I have a meeting for 1 hour with Mr. Nadiem Makarim, our Minister of Education. So I will leave for 1 hour at 10 o'clock Indonesian West time, or 11 o'clock Indonesian Central Time. I will rejoin again. And if there are some question response, I'm happy to answer after this. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you, Mr. Ahmad Tokan Demanik. Really interesting presentation. And then I think we can move to the second speaker. But before the speaker start, I will read some of his biography. Okay. Second speaker also has a great track record. Yes. Professor Nadir Shah Hussain is a diaspora from Indonesia that successfully in Australia. Professor Nadir Shah Hussain has been working as a senior lecturer at the Faculty of Law, Monash University since 2015. He has bachelor degree from UIN Syarif Hidayatullah Jakarta, and then graduate in Diploma of Islamic Studies, and then continued to the Master of Arts with honor in University of New England, and then Master of Law, Comparative Law in Charles Darwin University. And then he completed first PhD at University of London, and the second PhD is Islamic Law at the National University of Singapore. He had published many journals and books relating to human rights, such as Human Rights, Politics, and Corruption in Indonesia, a critical reflection on the post-Suharto era. And then in Indonesian law, Nadir has made a significant contribution to understanding of the problem and the prospect of Indonesian law reform in 4 different areas. That's constitution, politics, human rights, and anti-corruption. I think that's for the short biography of second speaker. To Professor Nadir Hussein, the floor is yours. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. Wabihi nasta'in ala umuri dunya waddin. Wassalatu wassalamu ala Rasulillah wa ala alihi wa sahbihi ajmain, amma ba'd. Yang saya hormati Bapak Rektor dan para Wakil Rektor, Bapak Dekan dan Bapak Ibu Wakil Dekan dari Fakultas Syariah UIN Alauddin Makassar, panitia, Bapak Moderator, terima kasih atas kesempatannya. Thanks for having me, and also sahabat saya Pak Taufan Damanik, and also other speakers. I'm going to share my screens. Okay, so the organizing committee has asked me to deliver my presentation in English, and the topic given to me is about COVID-19 and human rights in Australia. So I will not talk about Islam and human rights or human rights in Indonesia, because specifically the committee asked me to cover the experience of Australia during this COVID-19 pandemic. So first of all, there is a success story of Australia maintaining the COVID-19 pandemic. It wasn't easy to illustrate what happened last year in Victoria or in Melbourne. So Melbourne is the capital city of Victoria, the states, one of the states in Australia that currently I'm living in Melbourne. We had a lockdown, I think the longest in the world, nearly 4 months last year. And then after that, Australia, particularly Victoria here in Melbourne, successfully maintained the lower cases of COVID-19. So as you can see, here the update, we have 0 new cases acquired locally, and we only have 2 cases acquired overseas. And then together in Melbourne now, we only have 3 active cases and 0 life loss. So it means that this is the curves is already flat. It's people no longer need to use a mask or masker. And then now in my university, Monash University, I teach face-to-face, no longer online, because of these success stories. Of course, this is different with what happened in Indonesia right now. So let's hope that Indonesian government can also maintain the COVID-19 pandemic in a better way. So as we know that the outbreak of COVID-19 require quick, decisive, and effective action to be taken by all the governments, including Australian governments. And then we need to know that Australia is a federation of 6 states, which together with 2 self-governing territories, ACT, Australian Capital Territory in Canberra, and Northern Territory in Darwin, have their own constitutions, parliaments, government, and laws. And the states are New South Wales, the capital city is Sydney, Queensland, capital city is Brisbane, South Australia, Adelaide, Tasmania, Victoria, Melbourne, and Perth in Western Australia. So these are the background of Australian governments. And then in terms of human rights, the 3 states, Victoria, Queensland, and the Australian Capital Territory, have human rights acts that require the governments in those places to act consistently with human rights and to fully consider human rights law, policy, and practice. However, no such law exists at the federal level or other states and territories. So Australia is one of the only liberal democracies in the world that doesn't have its own Human Rights Act or Bill of Rights. So on one hand, we have the success stories of how the Australian government's maintaining the COVID-19 pandemic, but on the other hand, Australia doesn't have a Bill of Rights. So how we reconcile this situation? So whether the action taken by the Australian government, the Australian Commonwealth, state and territory governments in relation to COVID-19 will have breached the human rights or not is dependent on a form of proportionality analysis. Indeed, balancing competing public and private interests lies at the very heart of human rights law. So measures taken by the Australian Commonwealth, state and territory governments in relation to COVID-19 have raised a number of right issues. Of the particular rights engaged by the COVID-19 pandemic, there is on the one hand, the right to life and the right to health. On the other, there are such rights as the right to freedom of movement and to privacy, family and home, as well as the right to work. For present purposes, it is sufficient to state that the general obligation of government is to respect, protect, and fulfill these rights, which belong to all people universally simply by being human. However, this is not to say that all human rights are absolute and cannot be limited under any circumstances, even under strict conditions. Rights may need to be balanced against each other when in conflict, and rights may need to be balanced against other pressing concerns or matters that arise in society, such as public health emergencies. How a government responds to COVID-19 presents both types of conflicts. Human rights matter in the context of COVID-19 because they impose an obligation upon government to respect, protect, and fulfill the rights to life and health of every person in the community without discrimination, and to do so in a way that does not unreasonably or unjustifiably interfere with other human rights. The underlying principles of human rights enable governments to appreciate both the fundamental nature of this obligation and what is at stake for individuals and groups when limitations on rights are taken too far or to avoid doing so. So in my presentation, I will focus on 3 issues: freedom of movement, the right to privacy, and the right to work. So at one level, the purpose of this freedom of movement is obvious: to ensure that people and families and groups can move freely when and where they wish. Important though this is, it is not an adequate understanding of the entire meaning and importance of the right. So individuals usually want to exercise freedom of movement for reasons that are important to them personally. So stay at home or do not travel directions interfere with these experiences and make for a life that is smaller and less fulfilling. One of the most significant human rights implications of the COVID-19 measures relates to the restriction on freedom of movement. I recall, I think, a couple of weeks ago, Indonesian government make a decision to restrict back to village, mudik, because we will have a Ramadan, inshallah, tomorrow, and after that, usually at the end of Ramadan, there is a movement of people back to village, mudik, and now due to the COVID-19, Indonesian government restrict that mudik traditions. So that's one of the issues of the freedom of movement during the pandemic. So restrictions have been implemented in Australia also within states and territories. For example, by requiring residents to stay at home, subject only to specified exceptions. And more broadly, notably through the closure of several state borders. Some of these restrictions on movement have been challenged at the Commonwealth level under the Constitution, as I'm going to explain one of the significant cases at the end of my presentations. To the extent that restrictions on movement are imposed by the governments of the ACT, Australian Capital Territory in Canberra, Victoria, and Queensland, these may be unlawful infringements of the protection of freedom of movement. So under Australia's international law obligations, the right to freedom of movement is the right to liberty of movement. In the Victorian Charter, it is the right to move freely within Victoria and to enter on or leave it and to choose where to live. So this is of a particular interest where police fine people for breaching the directions on social distancing. Many of these directions have been criticized, including by senior members of the police themselves in Victoria, for lacking clarity, resulting in inconsistent application. Police are public authorities or public entities and are therefore bound by the conduct obligations set out in the Victorian Charter, including to act compatibly with human rights and give proper consideration to human rights in their decision-making. Further, if these fines from $300 to $5,000, so it's quite a lot if we convert to rupiah, if these fines are being inconsistently and unjustifiably applied to certain minority groups, this discrimination may also a breach of the right to equality. A range of other rights issues have arisen. For instance, Victoria Police arrested and fined activists holding a car convoy protest outside a hotel in Melbourne, where refugees and asylum seekers were being detained. This action may have infringed rights relating to protests, such as rights to freedom of expression, peaceful assembly, and freedom of association, and taking part in public life. In addition, the subject matter of the protest raises human rights concerns. Detentions and quarantine may increase a person's risk of contracting COVID-19, which raises questions as to whether the government has fallen foul of the requirement for humane treatment while liberty is deprived, or even the prohibition against cruel, inhuman, or degrading treatment. Analogous claims about detention breaching human rights could be made by prisoners. Indeed, there are various potential rights issues arising in the criminal justice context. I read the term of reference or TOR provided by the organizing committee. That's why I touch these issues about the prisoners and the criminal justice systems. So for one, as Justice Fulton held in the New South Wales Supreme Court, the virtual hearing of a criminal case because of court closures in the wake of COVID-19 may not constitute a fair hearing, which is a right under the Australian law, as well as a common law. I think several weeks ago, we noticed how the trial of Habib Rizik Sihab also concerns about this virtual hearing, whether it should be face-to-face hearing or not. In relation to criminal detention, the possibility that rights have been breached may be heightened where prisoners are vulnerable to the effects of COVID-19 and or pose a low risk of reoffending if released. Furthermore, the circumstances may render the detentions of youth offenders disproportionate and therefore not in accordance with the requirement to act in the best interest of the child. These questions about criminal detentions also raise concerns about the right to life, which, at least under international law, imposes positive obligations on state parties to protect against a risk to the life of persons in their care. However, the right to life may also prove important in justifying many of the government responses, which have been taken for the direct purpose of reducing loss of life. We move to the second issue, the right to privacy. Under international law, as accepted by Australia, the right to privacy is the right not to be subjected to arbitrary or unlawful interference with one's privacy, family, home, or correspondence. In the Victoria Charter, it is the right not to have one's privacy, family, or home unlawfully or arbitrarily interfered with. Again, the purpose of this right is obvious. They encompass and protect the natural capability of individuals to exercise personal autonomy in the pursuit of their own aspirations and potential in their own private sphere. This includes aspects of private life that involve interaction with others, as in social, family, work, business, and also spiritual life. So the pandemic is also leading to greater state control and scrutiny over the private lives of its citizens through the use of latest digital surveillance technologies. When it comes to balancing measures that could help track and contain the virus and safeguard privacy of individuals, where is the line? The answer is not a straightforward one. On one hand, digital solutions are helping save lives by spreading health messages, increasing access to remote physical checkups and health alerts. At the same time, surveillance tools that trace individuals' location and their contacts present profound challenges to privacy, data protection rights, and also freedom of information. The community is accepting unprecedented restrictions on freedoms and closer surveillance in the name of public health. Trust in science and government has been critical to the community acceptance. For example, millions of Australians have downloaded Australia's COVID Safe Contact Tracing mobile app on the assurance by health officials that it will help to combat the virus and trusting the government's pledge to protect individual privacy. Tracking your movement and location are really important for the government during the pandemic. In Australia now, if you enter a restaurant, you need to register using the QR code. So in the future, if there is a new case of COVID, the government can contact you. In other words, the government is watching you. Work and study from home arrangements have led to the widespread adoption of new technologies that raise potential privacy and security concerns. Employers and education providers are adopting new surveillance practices, and the gathering of personal data has proliferated. The third issue is the right to work. International law, as accepted by Australia, recognizes the right to work, which includes the right of everyone to the opportunity to get his living by work which he or she freely chooses or accepts. Again, this right is obvious. This is really important. People choose to work because they need to survive. And work is intimately connected to human dignity. As the United Nations Committee that oversees implementation of these international rights states, the right to work is essential for realizing other human rights and forms an inseparable and inherent part of human dignity. Every individual has the right to be able to work, allowing him or her to live in dignity. The individual usually has much more at stake in work than money. Therefore, the government's decisions for people to work from home interfere with much more than that. The restrictions may be reasonable and justified, but let us not misunderstand what work means to individuals in human terms in the justification calculus. So, can the limitation of human rights be justified? So we already learned how important those human rights, and we need to maintain those human rights. But at the same time, we have the pandemic, we have the emergency situation. Can the limitation of human rights be justified? So upholding fundamental democratic values founded upon respect for the universal and equal dignity of the individual, human rights limitation principles recognize, circumscribe, and guide the exercise of the exceptional power of governments to limit human rights for important public purposes, generally and in the COVID-19 situation. An exact answer to the question whether a limitation is justified depends upon the test applying to the particular right in the particular context. Under the International Covenant on Civil and Political Rights, ICHR, for example, measures derogating from the obligation to respect and ensure certain rights are permissible in the case of officially proclaimed public emergencies, but only, among other things, to the extent strictly required by the exigencies of the situation. Under the International Covenant on Economic, Social, and Cultural Rights, rights may be limited, but only, among other things, solely for the purpose of promoting the general welfare in a democratic society. Certain rights, such as the right to privacy, confer protection against arbitrary or unlawful interference, which are words of limitation having a well-understood meaning in relation to that right. So then, to be justified, the limitation must satisfy certain limitation principles as follows, if I can summarize them: legality, necessity, legitimate purpose, proportionate, and non-discrimination. The legality requirement upholds the rule of law and ensures that in limiting rights, governments are subject to law and democratically accountable for any change to the law, for it is under law that individuals enjoy their human rights. The necessity requirement ensures that absent this basis for limitation, individuals can enjoy fundamental rights and freedoms in their precious unlimited form. The legitimate purpose requirement ensures that the power of governance is not abused when limitations are imposed. The proportionality requirement ensures that limitations go no further than necessary. which is a guard against government overreach. The limitations must also be proportionate to the interest at stake. It must match and not exceed the protective purpose and be the least intrusive options for achieving it. The non-discrimination requirement ensures that, consistently with the basic democratic principles founded upon respect for human dignity, limitations are not discriminatory. A purpose of the limitations principle is to influence the exercise by governments of the limitation power so as to ensure that human rights are respected, protected, and fulfilled as far as possible in the situation. Application of the principles in the deliberative processes of good governance should lead to the result that when limitations are necessary for legitimate purposes, they are minimally intrusive, time-bound, targeted, proportionate, certain, non-discriminatory, and transparent. So the final issue that I'm going to talk is about a case law. So I already mentioned earlier that a number of cases that challenge the government's decisions during the COVID-19 pandemic in Australia on the grounds of human rights principles. And then I'm going to explain one of these important cases. So a number of states and territories in Australia have introduced various border and travel restrictions in response to the COVID-19 pandemic, typically by way of delegated legislation made in the purported exercise of powers under public health or emergency legislation. So on 15 March 2020, the Minister for Emergency Services for Western Australia declared a state of emergency in Western Australia in respect of the COVID-19 pandemic. Section 56 of the Act empowered the Minister to declare a state of emergency, provided, among other things, they were satisfied of the occurrence of an emergency and that extraordinary measures were required to prevent or minimize loss of life, prejudice to the safety, or harm to the health of persons. Section 67 relevantly empower an unauthorized officer for the purpose of emergency management during a state of emergency to direct or prohibit the movement of persons into an emergency area. The directions issued by the State Emergency Coordinator took effect from 5th of April 2020. Pursuant to paragraph 4 and 5, they prohibited entry of persons into Western Australia unless they were the subject of exemptions. Mr. Clive Palmer, a famous businessman in Australia, who did not otherwise meet the definition of an exempt traveler, applied under Clause 27R for written approval to enter Western Australia from Queensland in connection with his business activities as a director of this company, Mineralogy. However, Mr. Clive Palmer's request was denied, and as a result, he was prohibited from entering Western Australia. So Mr. Palmer and the company launched proceedings in the original jurisdiction of the High Court against the state of Western Australia and the State Emergency Coordinator and Commissioner of Police, Christopher Dawson, seeking a declaration that the direction and or the act are contrary to Section 92 of the Constitution and invalid. So Section 92 of the Australian Constitution states that trade, commerce, and intercourse among the states shall be absolutely free. Section 92 contains not one but two constitutional freedoms: the freedom of interstate trade and commerce, and the freedom of interstate intercourse, meaning movement. The two freedoms are related but distinct. It is possible for a given law to violate none, one, or both of these freedoms. So the case that I explained to you here on the Western Australia border restriction is being argued on both of the freedoms in Section 92, freedom of interstate trade and commerce and freedom of movement. However, the High Court rejected Mr. Palmer's challenge. According to the court, Section 92 of the Constitution was concerned with freedom from unjustified burdens of a discriminatory kind. So the word absolutely free is interpreted by the High Court as a freedom from unjustified burdens of discriminatory kind. The court accepted that Section 96 of Western Australia Act did impose a burden on interstate intercourse or movement. However, by reference to the purpose of the provisions and statutory constraints on the declaration of a state of emergency and the making of directions, the court found that the burden was justified and the provisions, at least in their application to an emergency constituted by a hazard in the nature of plague or epidemic, did not infringe the constitutional limitation in Section 92. At paragraph 80 of the joint judgment of Chief Justice Susan Kivel and Justice Pat King, they write, and I quote here, the defendant's submissions, that the Western Australia government submissions, that there is no effective alternative to a general restriction on entry must be accepted. So this means that from the High Court decision, the restriction is reasonably necessity during the pandemic, and there is no other options that is less restrictive to protect the community from COVID-19. In other words, the High Court believes that the restriction was not discriminatory and border closure was effective at preventing potential catastrophic spread of coronavirus. That's the end of my presentations. Once again, I thank you for your invitation, also for your opportunity. It's an honor for me to deliver my presentation here. But I have to excuse myself because of the time difference between Makassar and Melbourne. I have to prepare for my teaching because now it's still teaching time in Melbourne. So once again, thank you very much, and hopefully we can see each other again face to face in Makassar, inshallah. Subhanakallah ilma lana illa ma'alamtana innaka antal alimul hakim. Maksudnya ya Rabb, sungguh kami tidak punya ilmu apapun kecuali apa-apa yang telah Engkau ajarkan kepada kami. Wallahul muwaffiq ila aqwamit thoriq. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you very much for Professor Nadir Shah Hussain for the great presentation. So we have now the new insight, the new knowledge about our human right protection and enforced in Australia perspective. Thank you so much, Prof. Nadir. And then
ya, sekalian saya pamit ya Pak Moderator, saya pamit ya. Makasih semuanya.
Thank you, Prof.
Bye-bye.
Okay, so the next speakers also is a great speakers. The name is Dr. Megan Campbell, LLM. Megan Campbell is a lecturer in law at University of Birmingham. Her research explores how the international human right can be best respond to gender inequality and poverty. So, she has a monograph about women, poverty, and equality, and then published in 2018. It's about explore how the concept of equality in the UN Convention on the Discrimination on the elimination of all form of discrimination against women, or we can say CEDAW. Okay, and then she has published peer-reviewed articles on gender equality, human rights, international legal system, and public law, and provided written evidence to the Joint of Committee on Human Rights, Women and Equality Committee on Brexit, British exit, and human rights. I think Dr. Megan Campbell already here with us in the joint the Zoom. So, to Dr. Megan Campbell, floor is yours. Thank you.
Great. Can everyone hear me okay? Someone can give me a thumbs up if they can hear me.
Okay, you can.
Perfect. Just making sure that technology is working okay. Good morning. It's very early in the morning in the UK right now, so apologies if I'm a bit slow. It's about a little bit before 3:30 in the morning in the UK. So I'm very, very happy to be here, and my presentation is going to be looking at what does the right to equality bring to legal and policy making in relation to COVID-19. And I'll be focusing specifically on the UK and what the UK legal framework, how it can be used in relation to COVID. We can see that although COVID-19, we're all susceptible to it, we're all potentially able to catch it, it is not a great equalizer. It's actually a great revealer. It's revealing inequalities that exist within British society and helping us see more clearly how our current thinking has actually been used to cement and exacerbate inequalities. And so when we can see that the impacts of COVID-19 are being experienced so differently among women, among Black people, among ethnic minorities, around disabled, around people who live in poverty, the question then really becomes, well, what role can equality law play in redressing the inequalities that have been revealed by COVID-19? And in my presentation, I'm going to argue that there's a lot of existing potential within existing equality law, but the problem is that both policymakers and courts need to apply a more searching and nuanced understanding about what does the right to equality mean? What does it mean to be treated as an equal for this potential of equality law in relation to COVID-19 to be really realized? And perhaps most importantly, it needs to be recognized that the right to equality consists of more than treating likes alike, that equality is more than consistent equal treatment. And that to achieve equality might be required to treat people differently, that treating women differently, treating Black and ethnic minorities or disabled people differently than other groups might be required to achieve an equal outcome. It requires, what right to equality really requires is an appreciation of the complex ways in which disadvantage, stereotyping, lack of political voice, and structural obstacles interact to cause and sustain inequality. That means that when we think about what it means to be equal during and after COVID, that we have to think of equality in a multidimensional way. It's not just about consistency, but it's recognizing that due to stereotyping, lack of voice, histories and patterns of disadvantage, and structural obstacles, people are marginalized, oppressed, and excluded. And this presentation is going to do three things. First, it's going to look at what are these unequal impacts of COVID-19. It's going to look at the legal structure that exists within the UK and suggest ways of thinking about equality law for the future. So turning to the first, how has COVID-19 impacted life in the UK? And as I said before, it's not a great leveler. It's been a great revealer. It's really shown and highlighted the unequal pressure points or unequal fractures within the UK society. Obviously, the economic shocks of COVID-19 have been immense. What's interesting about COVID is that the economic shocks have tended to fallen most severely on non-standard workers. And I mean by non-standard workers, people who work in the gig economy, people who work part-time, people who work zero-hour contracts, people who work in very precarious forms of work. And most of these people have tended to be women. Women, because of their caring obligations, because of the disproportionate care that women still perform, women tend to be clustered in temporary or part-time work. And these are the industries that have most likely been economically affected by COVID. The statistical data has shown that women are more likely to have lost their jobs because of COVID, that young women, as opposed to older women, have been more likely to see reduced hours. So it's interesting, we can see an intersectional lens shows us a bit more richly the complexity of COVID. It's the intersection of age and gender that is explaining why young women are seeing more reduced hours. COVID-19 is also, I guess, interesting and devastating in equal measures, because more typically when recessions and economic downturns hit, they usually hit more male-dominated sectors of the society. We can think, more generally like construction. The pandemic is very different in how the economic shocks and the industries that have experienced economic shocks. Because of social distancing and lockdown measures, this has really dominated sectors of the economy that are dominated by women. So you think of hospitality, which in the UK is where women tend to congregate as in work, personal grooming, getting your hair cut, getting manicures, pedicures, all that kind of stuff. All those tend to be dominated by women. Those have all been shut for long periods of time. In the UK, schools, nurseries have all been shut. Again, these tend to be areas that women congregate for employment. And because of this, that they have been shut out from economic employment. And for the UK, we've been in kind of a hard version of lockdown for the last 6 months. But 6 months that they've been unable to really work. Particularly with the shutting down of schools and kids being at home more, women are doing more of the care work that would have been typically done at kids at school during the day or by nurseries or daycare programs. Those have been closed, and women are absorbing this additional care work. And the data is showing that regardless of income, women are spending less time on paid work and more time on caring work. So whatever income a woman makes, she is the one that was in the family absorbing the care responsibilities in relation to COVID. And we can see that the government's economic schemes to help offset the impacts of COVID have not been particularly sensitive to women's working and caring realities. So for instance, there's a salary retention scheme, which I'm broadly saying is that it could have changed a bit because the rules have been changing quite quickly, but largely it's 80% of your salary. But this is based on pre-pandemic earnings. So whatever you earn pre-pandemic, you would get 80% of your salary. But that just cements or ossifies the gender pay gap. We know that women are paid less than men throughout all of the economy. So having a salary retention scheme based on your previous income is just replicating the gender pay gap that already existed. Moreover, these salary retention schemes, these what we're called furloughed, don't match the reality of all women's employment. So non-standardized women workers, women who might be self-employed, like hairdressers, or women who work in the gig economy, they often are falling through the cracks of these programs and are not, because of their different sort of employment relations, are not sort of standard employer-employee, and they're falling through the gaps and not receiving any state protection. It's also, we can see from the data that non-standard women workers are more likely to just be offered less hours. So they're going to get reduction in hours, reduction in pay, rather than to be furloughed and take advantage of the full salary retention scheme. We can also see that women have increased risk of violence. The number of domestic violent killings appears to have doubled during lockdown. So there's increasing examples of extreme forms of gender-based violence because of COVID-19. We can also see that families have lost work. There's been a rise in child poverty, a rise in child hunger, and a rise of food insecurity. And the government has schemes in place to offset the impacts of loss of income, the impacts of income poverty through a complicated series of social benefit systems. But there's a cap on these benefits. So you might be entitled to a certain amount of benefits. You go through your list of entitlements, and this is the benefits I'm entitled to, but the government's going to cap at a certain dollar amount how much you're entitled to. So even though you might be entitled to things beyond the cap, the government says, no, you only get this capped amount. And because of this, lots of the schemes to offset income poverty have not been particularly effective for those most in need because of this benefits cap. You can only get amounts of the cap, and then you're no longer entitled to benefits. So COVID has both created and exacerbated pre-existing inequalities, and the government's response has really failed, particularly on the basis of gender equality, to understand how pre-existing gender equalities, racism or ableism, have also deepened income inequalities. And given that we can see in the UK society that burdens of COVID are shouldered by individuals who have protected characteristics in equality law, I'll turn now to think about, well, what kind of equality and anti-discrimination law bring to government policymaking? And so in the UK, there are two pieces of legislation that are really important: the Equalities Act and the Human Rights Act. The Equalities Act has a very, very interesting provision called Section 149, which requires that the government have, it's also known as a public sector equality duty, and it requires that the government have due regard to the need to eliminate unlawful discrimination, advance equality of opportunity, and foster good relations between people who share protected characteristics and people who do not. So what that means is that when the government's making any law or policy, there's a requirement before it passes that law or policy that it have due regard to the need basically to eliminate discrimination and achieve equality of opportunity. So this is a really interesting, proactive, positive duty that requires the government to have due regard. And the UK courts have been very clear that the public sector equality duty must be fulfilled before the law comes into place. So there's a requirement to have this thinking about equality beforehand. The duty has to be exercised in substance, with rigor, and with an open mind. So the government has to think in an open-minded, rigorous way about whatever law it's going to do, how is it going to affect on groups who are disadvantaged in this society. And it requires that the government conduct data and evidence about the potential impacts of this law on particular groups. And in some cases, it might require consulting with groups who are going to be affected by the law. But importantly, it's only a duty of process. The government only has to have due regard to consider equality. It's not an obligation for the government to achieve equality. So all the government has to show is that there's been some consideration, a substantive, rigorous one, but of what the unequal impacts of the law might be, but there's no requirement for the government to achieve any type of equality. And the second legal framework is the Human Rights Act. The UK is part of a regional human rights system called the European Convention of Human Rights. And the European Convention is domesticated or brought into UK law via the Human Rights Act. And Article 14 of the European Convention, Human Rights Act, requires that in the enjoyment of convention rights, non-discrimination. So one of the more important convention rights in this context is obviously the right to private life, and we have an equal right to private life. So while these potential frameworks have a lot of promise and might seem as a really strong foundation for thinking about what does a right to equality mean in relation to COVID, this full potential is not really being realized, I would argue. The public sector equality duty has been interpreted in a very light touch manner. And as I said earlier, only requires the government to have due regard not to take any positive or concrete steps to achieve equality. It's only a process duty. And the courts tend to interpret this in a way that's, I would argue, very deferential to government. The courts have also applied Article 14, the right to equality in convention rights, in a way that's also very highly deferential to the government, especially in relation to fiscal and social policy. It tends to ignore, when it looks in the realm of social and fiscal policy in relation to the right to equality, it tends to only focus on income equality. Does this law or policy make someone income-wise richer or poorer? But it ignores how the law can exacerbate stereotypes, how it can perpetuate stigma, or how institutional structures can exacerbate inequalities. And the courts tend to be overly deferential to the court's rationale for the reforms. So the law on paper looks really strong, but in reality is a bit thin. So turning to the what could we aspire to post-pandemic? How could we rethink our law as to address the inequalities that COVID-19 has both created and shown up? And turning first to the public sector equality duty. So this is a duty that requires them to think about equality before it passes any law. And the government has conducted equality impact assessments in relation to many of the laws and schemes it has made in relation to COVID-19, but we can't see them. There's equality impact assessments where it's sat down and thought, what is going to be the equality impact of closing down schools for 6 months? It says it's conducted an equality impact assessment where it's looked at the evidence and considered what might be the potential in unequal impacts of this law, but it's not made it public. Because the UK Equality Centre said it would have a chilling effect on the frank assessments needed in relation to COVID. The UK Parliamentary Committee has kind of argued back, well, in a fair and democratic society, we should have an open conversation about equality assessments. It allows for everyone to be able to see and scrutinize the government's work to make sure it is conducting a substantive and rigorous equality impact assessment of proposed laws to show that it has had due regard to its legal obligation to work towards eliminating unlawful discrimination. So we argue in an article I wrote with some colleagues that in fulfilling the public sector equality duty, it's imperative the government conduct equality impact assessments, that it consider both quantitative and qualitative evidence to assess what might be the impact of a law, and that these be participatory, that part of the equality impact assessment and thinking about what the law is going to do requires talking to the people who are most likely to be affected by the law. It's not just high-level elite academics or policymakers or politicians thinking about, well, I think the law is going to have this impact, but it's talking to the people on the ground most likely to experience the impact of the law. Because recognizing that as much as we can be creative and empathetic thinkers, we're never going to be able to truly understand the impact of a law without talking to those who are going to be affected by it. And therefore, it's really important that the government be open and transparent about its equality impact assessments and doesn't hide them. We also argue that the government has to adopt a substantive equality approach to equality impact assessments and to its understanding about its equality obligations under the European Convention. And rather than trying to say equality requires consistent equal treatment, we argue that equality is a substantive concept and has to pursue 4 overlapping aims. An equality law must be looking to break histories and patterns of disadvantage. Equality law should seek to eliminate stereotypes, prejudice, and stigma. Equality law should seek to facilitate voice and participation, recognizing that because of histories of disadvantage, certain groups are often excluded from political participation. And equality law should seek to ensure that the structures of society are not based on any sort of male paradigm, but are inclusive of everybody and valorize difference. And so thinking about what this might mean for an impact assessment, if you decide to shut down schools, if you decide that only certain types of people are entitled to a COVID-19 benefit, you have to think about, well, what does it, if we restrict our benefits to only people who are working in the economy, what are we saying about the people who are not working? How are we going to make sure that we've invested in structures so that everybody's able to access healthcare? How are we going to, if we shut down public libraries, how is it going to impact on people who don't have access to the internet except through a public library? So we want, and we have to do this against all of our protected characteristics. So if we shut down schools, who's going to take care of children? What kind of systems have we put in place to make sure that women are not burdened by having disproportionate levels of care put on their shoulders? If we're going to shut down libraries, how are we going to make sure that older people are able to access the internet? Particularly important when we think about that access to lots of social benefits now is premised on being able to access the internet. So we want to see the government, when it's thinking about what it's going to be doing in relation to COVID, to be doing a really rich and substantive equality impact assessment that is evidence-based, participatory, and thinks about pre-existing patterns of disadvantage, thinks about how the law might express stereotypes about deserving or undeserving people, and how it can ensure that the structures of our society are inclusive of all. And when we turn to the courts, we want to make sure that when the courts are reviewing government law and policy in relation to COVID, that they're doing so in a rigorous manner, that they're really unpacking the inequalities at play. And the British courts have argued in a couple of papers, when they're reviewing economic and fiscal policy, they tend to only focus on economic inequality. The law makes someone richer or poorer, but they don't tend to focus a lot on how the law might be expressing value towards disabled people, or how the law might be expressing value towards lone mothers who take care of their kids. So the courts need to be applying the substantive model of equality to really tease out the interaction between income poverty and stereotypes, prejudices, and stigmas. And then the courts also need to be giving a very rigorous assessment of rigorous assessment of the government's reasons for the law or policy. So it has to make sure that it's looking very carefully at, well, the government wants to pursue this policy to protect us, to keep us safe from COVID. That's obviously a very legitimate aim, but we want to make sure that its aim is proportionate. So if it's going to be inflicting discrimination against a group of people to keep everybody else safe from COVID, we want to make sure it's doing it in a way that's proportionate, as the previous speaker went through on his slides. And that means we want to make sure the government is coming to court with evidence, bring the evidence about why this policy is necessary, or the least intrusive measure to make sure that people are kept physically safe. So I see my time is kind of coming to an end. Do you want me to answer the questions in the chat now, or would you prefer me to save them for later?
I will open the question and answer session. So, Dr. Campbell, you can answer the question.
Okay, so I see Yenny has a question. What do you think the solution to the rights of the individuals whose rights limited making a living, especially in lower middle class communities? This is comparison between law and human rights protection. Thank you. So I think this is one of the tough ones, is that obviously with lockdowns, certain types of professions are going to be more impacted than others, particularly in the UK, hospitality. That industry is now, basically been shut down for 6 months. And this is where having a strong social security net becomes really important. Many industries have to close to keep people safe because it's been very hard to do social distancing in them, and so they have to be shut to keep people safe. But those individuals who work in the industry, their needs to pay their rent and put food on the table do not go away. So ensuring that there is a strong social safety net and strong social benefits in place, that those people are not hungry or destitute, is so, so, so important. And I think in the UK, it's been particularly revealing because since the economic crisis in 2008, there has been a significant reduction in the social safety net. And this has And many of this has been based on the ideas that people who are in poverty don't work very hard. People are in poverty because they are unmeritorious, because they are lazy, because they are work shy. And that's a very strong stereotype, very prevalent in lots of social policy making around poverty in the UK. And COVID has shown us that it's not because people don't want to work that they're not in work. There might be very complicated reasons why people can't work, especially in COVID. They're not working because they are making a sacrifice and keeping other people safe. And the kind of social solidarity that people are doing to keep people safe should help us realize that these really pernicious attitudes of people in poverty as being lazy need to be removed and gotten rid of from the social safety net. So to answer your question, there's no simple answer, because at least in the UK, so much of the social benefit system is based on this really cornerstone idea that people are poor because they're lazy and don't like to work. Hopefully COVID will show us that that has not been true and has never been true, and that social benefit law and policy can change to recognize that people come in and out of work for many, many reasons, and that their needs for housing and food do not change, and that the social benefit system will be based more on recognition of solidarity and human need, rather than on trying to punish people for being poor, or trying to spur thinking people are really lazy and need to be forced back into work. I hope that answers your question, Yemi. I think there was another one here in the chat. Whether the restrictions of human rights by the government areas cannot be considered violation of human rights. So there is lots of interesting work being done in the UK about lockdowns and human rights. There are some people who do argue that, obviously a lockdown on the paraphrase is a restriction of your freedom of movement, your freedom of assembly, your right to protest, etc. But as I think the previous speaker mentioned, they're all human rights, not all, but the vast majority, can be limited to pursue other legitimate aims, such as public health. So there is systems within the human rights framework that allow for rights to be limited. They have to be done in a way that's proportionate. So they have to be done in a way that's sort of rationally connected. So, we're in a lockdown to keep people safe. There are links to show how social distancing is helping slow the spread of the disease. They have to be least intrusive, and they have to be a fair balance between the impact versus the outcome. And it tends, I would argue, it tends to be in favor of allowing the government a lot of leeway to impose lockdowns, because the health of the community is so important. We see in the UK 120,000 people have died, which is staggering numbers of people. To keep people physically alive and physically safe, human rights law does allow some restrictions on rights. There are debates about, I think one of the interesting and challenging things about COVID is its novelty, and it's really important that the lockdown measures and any restrictions are constantly being reviewed as evidence comes to light about how COVID-19 is spread, the effect of vaccine rollouts, and what kind of measures are needed to keep us safe. So I think what's really important in any measures is that they're constantly being reviewed, and that they're based on evidence and science, not based on sort of pure politics, so to speak. I see another question here. Talking about COVID-19, we know that COVID greatly affects especially work, a lot of people losing their jobs. Will many people won't certainly be able to fulfill these outside the core Indonesian constitution? So I'm not a specialist in the Indonesian constitution, but I think your question is a very fair one about if the constitution has a decent livelihood as a right, which you can see something equivalent in the International Covenant of Economic and Social Rights, which is the right to adequate standard of living. We can see that the economic impacts of COVID have resulted in people being materially significantly worse off. it does should make us think, well, is this a violation of a right to decent livelihood, a right to adequate standard of living? And it can be challenging to make those arguments because at least I know, apologies, I'm not an Indonesian specialist, but at least in the International Economic Social Rights Covenant up at the UN, these type of rights are subject to progressive realization and maximum available resources. And so the government will be able to argue that, well, your right to adequate standard of living is contingent on the economic health of the state, essentially. And because of the devastating impacts of COVID-19, we're going to have to, kind of downgrade what an adequate standard of living is. I think actually this is where the right to equality becomes really important. If we see that, okay, so the amount of available resources for parks and everything that we take as part of an adequate standard of living has significantly been reduced because of COVID-19. But then when we look at see, well, whose livelihoods are having to take that downturn? If it's always the people who are at the more marginalized, at the lower end of a socioeconomic income, if we're only asking poor people to bear the economic brunt of COVID, if we're only asking poor people to experience violations of their adequate standard of living, and people who are very well off are not having to kind of bear any brunt of COVID-19, then we can see a real inequality. And that can be a stronger argument for courts, at least, because your right to equality isn't subject to progressive realization or maximum available resources. So apologies for not knowing the Indonesian constitution as well as I should, but, and there might not be maximum available resources progressive realization in the Indonesian constitution, but at least for the UN, your right to adequate standard of living is subject to those, which can make a difficult argument to make when there has been a sort of global economic downturn. How does the government enforce human rights in pandemic era? So I'm not a specialist in this, but just as a lay person reading the news, essentially, it's very interesting to see how these rules are enforced or not enforced. The scope of the stay-at-home rules in the UK is so broad that it's actually impossible to go from home to home to make sure that everyone's staying inside and not seeing other people from the household. And the rules depend a lot on the good faith of the community to believe in them and enforce them, which is why it's so important that both politicians and leaders themselves follow the rules and demonstrate commitment to them, because the rules of keeping people safe really depend on all of us believing them, because their scope and extent is beyond what any kind of police force could enforce. What can the government do to help? I think one of the things has been, it's hard, I mean, it is very hard to say what works and what doesn't. I think the sort of post-mortem on what works post-COVID is still to come. But one of the things I think is, two things are really important. One is that there needs to be a clear entitlement to sick leave. So if someone is feeling ill, they don't go into work, that they can stay at home, keep themselves and everyone else safe, and still have income. Because if you don't have good sick leave, you might feel you have to go into work to make ends meet. You might spread COVID to a much larger group of people, or any other kind of cold or disease, and we never get the numbers under control. The other thing I think is the government does have to be very aware of the clear need for a strong social safety net and clear need for social benefits when so many people are forced out of work, that the right to social security has become so important to offset the devastating economic impacts of COVID-19. People called Karens, that's kind of it's Karens are kind of a trope of a white middle class woman who's very angry at the world. And there's lots of interesting work being done to show how gendered this is, because actually women are quite good at following the rules, and it's definitely a trope. It's a very Western trope about, and there's some stereotypes do about women that are a bit pernicious, but it's this idea that it's someone who always challenges authority and yeah, do some Googling. It's just a kind of cultural trope. It's not anything more than that. I don't have any expertise on Australia, so I might pass that one. I don't have a lot of knowledge about terrorism, Yasser, but I think what's hopefully becoming revealed by COVID is how our access to social benefits, particularly in the UK, is often contingent upon working, not working, or being able to seek work. And that's true for other countries as well that I am more familiar with, but the idea about your access to benefits, your access to the social safety net is so conditional on that working relationship, that kind of standardized employment relationship. And as we can see, COVID kind of has thrown everything into disarray, that one can hope that the access to the social safety benefits, to the social safety net, is no longer so conditional upon being in a standardized working relationship. That could hopefully be a way forward that ensures people are kept safe without requiring them to work, because obviously accessing employment right now is very, very difficult.
Dr. Megan.
Yes, I'm probably running over your time and screwing up your schedule.
No problem. I think that there are many questions for you because of your interesting presentation. I will read two questions from the committee here. First is, the young woman is vulnerable in this COVID pandemic, and then how the UK government solved this problem while the lockdown implemented. And the second is, how about the freedom of expression in the UK during the pandemic? Thank you.
Yeah, two good questions. I don't think the UK has done a great job at redressing young women's vulnerability to the economic impacts of COVID-19. I think that is something that still needs to be fully addressed. I think the way the benefit system has worked has definitely left some people out, and there needs to be a rethinking of that. Although we're just about to get out of lockdown in a couple hours on Monday, April 12th. So I think that there are serious groups who have been left out of the system that the UK has created to offset the economic impacts of COVID-19, and young women is just one example, but there hasn't been much to redress the vulnerability created. Second question about free speech. I'm not a free speech specialist, but there have been, if you take a look in the news, there's been lots of issues around right to protest during the pandemic. There have been some very high profile and very tragic instances of extreme gender-based violence where women have been murdered. There have been protests and rallies against gender-based violence against women that have been very heavily policed, and the UK has been heavily criticized for its policing of these protests. And there's now been introduction of a series of laws to restrict the right to protest. So there is right now concerns that freedom of expression, particularly around protesting, are going to be curtailed. So this is something that's happening just as we speak. So there are real questions and concerns that freedom of expression is being diluted and restricted in the current political moment. So do you want me to keep answering the chat questions? I can answer them in the chat if that's easy, so you can, I don't want to screw up your timing for your program.
Okay. Thank you, Dr. Megan, for the presentation and the answer of the question. But I see that there are many questions for you. But before we open the next question, I want to announce that unfortunately, Mr. Dr. Sebastian Spitra, the next speakers, cannot join us today. It's happened by an accident. I hope he will get in a good health and condition. And then, okay, the next session is a question and answer session. But because the Professor Nadir Syed Hassan cannot join us to present the question and answer session, so I think the question will be for the Dr. Megan to do the first, and then the Mr. Ahmad Taufan Damanik, the first keynote speaker, will come on 11 o'clock. So I hope Dr. Megan can answer several questions more and then finish the session. Is that okay, Ms. Dr. Megan?
Yeah, no problem. So I'm just looking in the chat right now, which questions I haven't answered. The ones with the death penalty. Again, I would argue the death penalty is a violation of the right to life. I'm Canadian, living in the UK for the past 10 years. Both Canada and the UK have prohibited the death penalty. Yes, no, the death penalty under my understanding of the right to life is a violation. I saw a question about religion. Let me scroll up in the chat here. I'm not entirely sure if I understand the question about the violation of religious values because of human rights violations. In the UK and in other countries, there have been clashes between the right to equality and the right to religious freedom, particularly around, again, I'm also some Canadian, around assisted death, around sexual orientation equality and religious freedom equality. And the courts have been having to wade through this, but depending on the jurisdiction you're on, some jurisdictions give more heavily, weigh more heavily the right to religious freedom, some jurisdictions weigh more heavily the right to equality. And it often will depend on the factual scenario of the case. But you know, there is a strong protection for religious freedom within both the UN human rights system and many national systems. Like I was mentioning earlier, and one of the earlier presentations mentioned as well, the right to religious freedom, like the right to equality, can be limited to protect other important values. So for some, and I would probably fall more heavily on this side, that the right to religious freedom can be limited to ensure equality for other groups.
I will read a question.
Sure, that'd be great.
It's from Muhammad Akbar. Does the restriction on community movement by the government in the area affected by COVID-19 can be classified as a violation of human rights or not?
So this kind of relates to the earlier question. I think, you know, if freedom of movement is going to be seen at, or restrictions on freedom of movement are going to be found to be a violation of human rights will depend on how proportionate the lockdown is. So that will depend on the data at the time about how high the COVID rates are, how intense the lockdown is. So it really comes down to the proportionality issue about the government wants to keep people safe, it imposes a lockdown. Is it proportionate to have everybody locked down to keep everybody else safe? It's that real weighing, balancing that human rights requires. Courts in these type of areas, particularly where it's a new area where scientific data is constantly evolving, they tend to be very deferential to government decision making. At least definitely in the UK. Obviously, I can't speak to Indonesia in the same level of detail, but so what it will depend upon if it's a violation of human rights would be, does the restriction on the freedom of movement, is it disproportionate to the need to keep people safe because of COVID? So it really will turn on that proportionality, which then will depend a lot upon the extent of the lockdown, the extent of the restriction, and the risk to health at the present moment.
Thank you. I think one last question for Dr. Megan. In this COVID-19 pandemic, there are many uncertain, starting economic, social, and life. So, how the step of human right as a normative legal institution takes a stand against violence and right laws in the midst of COVID-19 pandemic? That's the question.
Yeah, that's a really good question. I mean, human rights has strong protections for security of the person, in cruel and human treatment, so strong protections against violence. But we can see that violence is increasing. I can speak in the UK context. Violence against women is increasing during lockdowns, and lots of the support systems that are in place often depended upon, physically going in contact with people, which has been cut off. So it becomes really important for the support systems in place to help people get out of violence, have adapted to the realities of life being mostly online. I can throw in the chat a submission I made to the UN Special Rapporteur on Violence, looking at different ways that the police can respond better to gender-based violence, the way that social services can respond better to gender-based violence. So I'll just throw that in the chat because it's not a very long one, it's a couple thousand words that might be interesting for people to look at.
Okay. Thank you very much, Dr. Megan. That's a really interesting answer. Then we will have to move to Mr. Ahmad Taufan Damani question, but while waiting the Mr. Ahmad Taufan Damani, let's watch the video of Department Universitas Islam Negara Indonesia. Okay, let's wait. Yes.
Program Studi Ilmu Hukum memiliki visi sebagai pusat riset, pengkajian, dan pengembangan keilmuan hukum yang berperadaban. Untuk mencapai visi tersebut, maka ada 3 misi yang ditempuh atau dilaksanakan oleh program Studi Ilmu Hukum. Yang pertama, menghasilkan sarjana hukum yang memiliki kemampuan menerapkan hukum di tengah-tengah masyarakat. Yang kedua, menghasilkan sarjana hukum yang memiliki kemampuan dalam menjalankan profesinya. Dan yang ketiga, mewujudkan nilai-nilai budaya hukum yang islami. Dalam menjalankan visi dan misi tersebut, Fakultas Syariah dan Hukum, Program Studi Ilmu Hukum memiliki beberapa sarana dan prasarana. Yang pertama adalah ruangan dosen. Ruangan dosen Fakultas Syariah dan Hukum itu berdiri sendiri di gedung dosen berlantai 3, dan masing-masing dosen Program Studi Ilmu Hukum memiliki ruangan tersendiri. Yang kedua, adanya laboratorium justisi. Dalam laboratorium justisi ini ada beberapa ruangan yang dijadikan sebagai ruangan praktek sidang. Kemudian ada lembaga konsultasi dan bantuan hukum. Lembaga konsultasi dan bantuan hukum ini memberikan jasa bantuan hukum baik secara litigasi dan non litigasi. Kemudian yang selanjutnya ada namanya klinik hukum. Klinik hukum ini adalah salah satu bagian dari kurikulum ilmu hukum, di mana dalam proses klinik hukum tersebut mahasiswa diharapkan bisa menjalankan profesinya sesuai dengan bidangnya keilmuan masing-masing. Kemudian selain laboratorium justisi juga terdapat ruangan perkuliahan, baik itu ruangan perkuliahan dalam lingkup Fakultas Syariah dan Hukum dan ruangan perkuliahan yang berdiri sendiri dan bergabung dengan beberapa fakultas yang lain atau biasa dikenal dengan istilah gedung terpadu. Kemudian tersedia juga sarana prasarana seperti ruangan lecture, yaitu tempat untuk mahasiswa melakukan semacam perkuliahan dalam jumlah kapasitas yang besar. Kemudian juga tersedia perpustakaan. Di perpustakaan tersebut beberapa referensi buku yang ada, baik itu hukum maupun hukum Islam. Bahkan di program studi ilmu hukum sendiri memiliki mini perpustakaan yang menyiapkan buku-buku hukum sebagai referensi mahasiswa dalam menyusun skripsi.
Akan mendapat pendapat tentang soal-soal yang akan ditanyakan kepada saya. Sesuai dengan kalian dan ilmu pengetahuan yang sendiri. Terdakwa dalam persidangan dan saudara terdakwa saudara status tahanan. Demikian sudah ditetapkan.
Majelis Hakim memasuki ruang persidangan.
Sidang lanjutan perkara pidana dengan nomor register perkara 085.
Sidang hukum salah satunya adalah pemerintahan berdasarkan peraturan perundang-undangan. Jadi kita sebagai anak hukum harus tahu. Jadi undang-undang yang penting bagi kita undang-undang dasar atau undang-undang terkait pemerintahan peraturan perundang-undangan. Itu ada di pasal
dengan ucapan Bismillahirrahmanirrahim, maka kegiatan ini dibuka dengan
Okay, thank you. Welcome, Mr. Ahmad Taufan Damanik. This session is a question and answer session. I will share screen some question from the participants. The first question is from Mr. Akam Jayadi. The question he asked to Mr. Ahmad Taufan Damanik. The first question is, how far the protection and enforcement on human rights in this country, Indonesia, has been maximally and thorough implemented, especially in political, economic, and religious field. Thank you.
Okay. Luckily, I think Indonesia has ratified several international instruments on human rights. For example, International Covenant on Political, Economic, Social, and Cultural Rights, and also International Covenant on Political Rights. So based on these two covenants, we have reviewed some national law or national regulation, including the national law on human rights, national law on education, and some others. Yeah. We also have national law on disability persons, referring to the International Convention on Disabled Persons. So there are so many international standard on human rights or international instrument on human rights already accommodated to our national regulation or national law, even to the local level. So through this regulation at national and local level, we can use it. We can use them, all of them, to protect and to promote human rights. As you religious fields, of course, we still have some problems. We still have some challenges related, especially related to the issue of intolerance. But we have some good and strong regulation on that. A couple of minutes ago, I discussed with Mr. Nadim as a Minister of Education. He also has a very strong concern on that in education system. So we will review the curriculum of education and also mechanism or procedure, yeah, that prevent bullying, prevent intolerance, or principle of, prevent the system of education from the practice of discrimination. So there are many regulations, including in local level, but on the other side, there are some regulation or policy or programs. It is against human rights that we need to review. We need to change those negative regulations or contradictions mechanism regulation to human rights standard. And then, what if human rights violations are also categorized as violation of religious value? I think human rights activists, human rights defender need to discuss deeply and also detailedly on the value and the human right or the value of and also human rights standard, human rights principle to the religious leader. I don't think that there is barrier on that. If both sides, I mean, human rights activists, human rights expert, human rights defender, has also similar concern on how we improve, how we develop our nation. Based on the national concern, I think every parties in Asia can discuss and can solve the problem of differences in our perspective, including our differences perspective in human rights. I think this is all our answer. Thank you.
Okay, thank you, Mr. The next question is come from Mr. Trisweta Bani.
Okay.
Yes. Okay.
Another one is a question from Tri Suhendra Arbani. Yeah? We have two mechanisms, two approaches. Yeah, one is what we call as a mediation. So if that we receive a complaint or report from the people or from the groups on the agrarian conflict, we can use the mediations method or mediations approach to invite all parties to sit together to find a solution. Of course, we have to consider the national regulation, the national program, also the local regulation and local value also. On the other side, we have another approach that we call investigation. Our team will be sent to the field to do investigation, and after that, we come up with some recommendation on the case that we have we were reported. Recommendation, of course, according to National Law 1999, number 39 year 1999, is not legally binding. That's another issue where some recommendation of Komnas HAM sometimes not being obeyed by the parties. But other recommendation or many recommendations usually obeyed by the parties who are receive letter or recommendation from Komnas HAM. So there are two things that there are two approaches that we can use. On the other side, we can also approach another ministries or institution like a Ministry of Agrarian or Ministry of Forestry and Environment or Ministry of State-owned Company, BUMN. And sometimes we have also cooperation with the local government like governor, bupati, so sit together in order to solve the problem of agrarian conflict. But of course, the case of agrarian conflict is so big. Thousands reported cases come to Komnas HAM every year. And it is almost all the cases is already a long time happened in Indonesia. Because of the historical and political background, and also because of the many policies or many regulations, but sometimes all policies or all regulations overlap among others. Thank you.
Okay. Come to next question.
Yeah, the third question, I think because General Attorney is a member of President's cabinet or President administration. So the solution is how the President of Indonesia declare or proclaim his vision how to solve the problem. And Attorney General, of course, should follow the direction from the President. what we are doing now is to discuss all the cases of gross violation of human rights to the President Jokowi and also to the coordinating Ministry of Politics and Security and Law, Professor Mahfud, and after that we negotiate with General Attorney Mr. Burhanuddin. But because sometimes we have a difference on paradigm or perspective, we again need the clear vision, clear direction from the President of Indonesia. And in the last 2 years, I think President already sent his clear vision how to solve the problem of gross violation of human rights in Indonesia.
Okay, next from Muhammad Sandi Azri about corruption by official against COVID-19 funding.
Yeah, on COVID-19, we actually have 18 recommendations that we already submitted to the President of Indonesia, Mr. Jokowi, and also to some governors, and including to the special task force led by Mr. Doni Monardo. And I think not all, of course, I agree that not all recommendations from Komnas HAM implemented by all parties, but day by day, I think gradually, there is an improvement from the program of handling COVID-19, not only from the central government, but also from the local government. That's why we see that day by day, the positivity rate of COVID-19 in Indonesia decreasing sharply, and I hope through the vaccination program, we will pass this pandemic. But I agree that some mistake or negligence from governments or at central and local governments is still there. But I have honestly say that there is improvement, there is a progress day by day, month by month, and that's why we see that positivity rate on COVID-19 in Indonesia is decreasing. I think that's all. Is there any question?
The next, 2 more questions, sir.
Okay.
The question from Tri Suhendra Arbani. It's about the freedom of expression in this pandemic. Indonesia, how about your opinion, sir?
Yeah, freedom of expression is fundamental human rights. But maybe you may read or study the standard and norms and regulation on the freedom of expression and assembly that already launched by Komnas HAM. I suggest you to read it from our website, or you may ask also my staff to send you that document. Yeah. In our document on standard and norms and regulation on freedom of expression, we also see that there is another dimension. Beside freedom, there is another dimension. Let's say a dimension of not doing, not giving, or not sending hoaxes or hate speech. We have a special chapter on hoaxes and hate speech also. So hoaxes, hate speech, or other bad things, it is not a part of a freedom of expression. So freedom of expression should be divided, or should be demarcated from 2 things that I already said: hoaxes and hate speech. Hate speech and hoaxes are the enemy of freedom of expression, also crimes, also according to our national law according to national standard. On the other side, in our standard and norms document, we write down also the issue of academic freedom. Academic freedom should be protected, should be respected, not only by the university, but also by the central government. In this case, of course, the Minister of Education that I already discussed a couple minutes ago. But on the other side, should be respected also by the third party, because sometimes there is a case where the third party outsider of university interfere academic freedom inside within university, and it is of course responsibility of police or other law enforcer to ensure and to protect the freedom of the people within the university. That's a similar question about the freedom of expression in public sphere, where police or other law enforcers has a responsibility to protect the freedom of expression as fundamental rights of the people. Of course, we have to distinguish freedom of expression from what we call it as a crime, hoaxes, a hate speech. In our standard and norm document, we write down clearly the freedom of expression in one side and hoaxes or other crimes on the other sides. Okay, thank you very much. That's all.
So we until the end of the panel session. Thank you for the presenter, the keynote speaker, Mr. Ahmad Damani, Professor Nadim Shah Hossain, Dr. Megan Campbell, and Dr. Sebastian Spitra. I think that's our session today, and we will continue it to the parallel session at 1:00 p.m. or 13 o'clock GMT +8 or Indonesia means time. And for the presenter, once again, I say thank you very much, and I hope it is not the end of our meeting. So if the pandemic over, I think we can meet in person next time. The good cooperation again. Thank you. So now I will close this panel session, and for presenter, just be ready for parallel session and take a rest for 1 hour. Then we'll continue. We use the same link. Okay. Okay. Assalamualaikum warahmatullahi wabarakatuh. Oke, untuk teman-teman peserta, panel sesi sudah berakhir. Saya sampaikan untuk bersiap, istirahat, dan bersiap untuk parallel session pada pukul 13.00 WITA atau jam 1 siang waktu Indonesia Tengah. Jadi dipersilahkan untuk rehat sejenak, dan link ini kami nanti akan tutup, jadi silakan gabung kembali. Ya, terima kasih. Dan nanti akan disampaikan ketika pertama masuk parallel session, nanti akan kami breakout room berdasarkan ruangannya masing-masing. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Universitas Islam Negeri Alauddin Makassar di bawah kepemimpinan Profesor Hamdan Johanis MA PhD, Kampus Peradaban dengan Pancacita, bidang akademik serta non-akademik.
Fakultas Syariah dan Hukum Universitas Islam Negeri Alauddin Makassar lahir pada tahun 1962 yang pada mulanya merupakan Fakultas Syariah di Universitas Muslim Indonesia yang kemudian berubah menjadi Fakultas Syariah IAIN Sunan Kalijaga, Yogyakarta, cabang Makassar. Pada tahun 1965 berstatus mandiri dengan nama Institut Agama Islam Negeri Al-Jabiyah Al-Islamiyah Al-Hukumiyah di Makassar. Fakultas Syariah dan Hukum memiliki visi serta memiliki misi pimpinan Fakultas Syariah dan Hukum periode 2019-2023 Dekan Dr. Haji Muammar Muhammad Bakri LC.MAD. Wakil Dekan 1 Dr. Hajar Rahmatiah HL.MPD. Wakil Dekan 2 Dr. Marilang SHMU. Wakil Dekan 3 Dr. Haji Muhammad Saleh Ridwan MAG.
Assalamualaikum warahmatullahi wabarakatuh. Secara ideal dan normatif, pengelolaan perguruan tinggi negeri di level fakultas dipastikan berjalan sesuai dengan kebijakan pemerintah, kebijakan universitas dalam mengaktualisasikan standar penjaminan mutu internal di tingkat fakultas. Sebagai perwujudan dari visi fakultas sebagai pusat riset dan pencerahan dalam ilmu syariah dan hukum, maka pimpinan fakultas mencanangkan Rumah Referensi Syariah dan Hukum Dar Al-Marajih Syariati wal Qanun. Diharapkan dengan kualifikasi dosen fakultas dapat menjadi narasumber dan konsultan bagi masyarakat di bidang syariah dan hukum. Demikian pula ide dan gagasan dosen kami dapat disitasi oleh akademisi internal maupun eksternal kampus. Selain kekuatan SDM yang kami miliki, secara kelembagaan dapat bersinergi dengan berbagai pihak untuk penguatan dan pengembangan yang terkait dengan ilmu syariah dan hukum. Sebagai lembaga pendidikan yang diharapkan menolorkan SDM yang kuat, maka berbagai kebijakan yang dilakukan antara lain meningkatkan kualitas dan kuantitas penelitian dan publikasi artikel ilmiah dari Sivitas Akademika ke beberapa jurnal nasional maupun internasional, termasuk 13 jurnal yang telah kami siapkan di tingkat fakultas. Integrasi keilmuan, syariah dan hukum menjadi kekuatan tersendiri bagi fakultas di wilayah timur Indonesia, serta kearifan lokal yang dimiliki menjadi power sebagai pusat pencerahan dan transformasi iptek di bidang hukum berbasis syariah. SDM syariah yang memahami hukum atau SDM yang menguasai hukum dan memahami syariah. Untuk terwujudnya hal tersebut, fakultas sebagai rumah referensi berupaya menciptakan suasana akademik dalam kampus dengan hadirnya literasi dinding di semua sudut ruangan, kaidah-kaidah hukum dan syariah yang menjadi standar keilmuan sivitas akademika menjadi bingkai keilmuan yang menghiasi pandangan mata para pengunjung. Demikian pula keasrian taman yang dilengkapi fasilitas Wi-Fi serta sarana lainnya seperti pendopo demokrasi, Bani Thaqifah, Tudang Sipulung, Syariah dan Hukum, miniatur Ka'bah dan beberapa laboratorium yang kami miliki sebagai sarana pendukung tercapainya fakultas sebagai rumah referensi syariah dan hukum UIN Alauddin Makassar.
Fakultas Syariah dan Hukum UIN Alauddin Makassar membawahi 6 jurusan yang telah terakreditasi. Jurusan Hukum Keluarga Islam, jurusan Hukum Tata Negara, jurusan Perbandingan Mazhab dan Hukum, jurusan Ilmu Hukum, jurusan Ilmu Falak, dan jurusan Hukum Ekonomi Syariah. Untuk mewujudkan pendidikan yang berkualitas, Fakultas Syariah dan Hukum menyediakan fasilitas pendidikan kepada mahasiswa untuk menunjang terselenggaranya perkuliahan, praktikum, dan pengembangan kompetensi mahasiswa.
Kampus kami terus berbenah. Kampus yang selama ini kami populerkan sebagai kampus peradaban. Kampus Universitas Islam Negeri Alauddin
November 1965 menandai lahirnya wadah pendidikan Islam bernama IAIN Alauddin Makassar oleh Presiden RI ke-6 Dr. Haji Susilo Bambang Yudhoyono diresmikan menjadi UIN Alauddin Makassar pada tanggal 4 Desember 2005. Peralihan status dari IAIN menjadi UIN ini menyematkan amanah besar kepada seluruh stakeholder dan sivitas akademika UIN Alauddin untuk menunjukkan komitmen kuatnya dalam mewujudkan tridharma perguruan tinggi dan visi misinya sebagai kampus peradaban yang melakukan pencerdasan dan pencerahan serta menjunjung tinggi prestasi dan inovasi. Sebagai kampus berlatar belakang studi Islam pertama dan terdepan di Indonesia Timur, UIN Alauddin Makassar memiliki dua lokasi kampus. Kampus 1, UIN Alauddin Sultan Alauddin dan kampus 2 terletak di Jalan Ibnu Yasin Limpung nomor 36, Samata, Kabupaten Goa.
Satu di sini toh Kak, depan lift. Hah? Satu di sini. Kak Wana di sini Kak. Iya.
Welcome to State University of Alauddin Makassar. Alauddin tumbuh dan berkembang bersama kuat seluruh elemen sivitas akademika untuk mewujudkan visi, misi, dan slogan UIN Alauddin sebagai kampus peradaban. Hal ini tidaklah mudah dalam mewujudkannya, tetapi kami yakin bahwa UIN akan terus berkontribusi sejalan dengan denyut nadi kehidupan mewarnai dinamika hidup umat.
UIN Alauddin diperkuat oleh 1.352 pegawai yang terdiri dari 812 orang pegawai negeri sipil dan 540 orang pegawai non-PNS. Dengan status jumlah dosen sebanyak 568 orang dan 38 orang diantaranya merupakan guru besar. Hingga saat ini UIN Alauddin Makassar telah berhasil mengukuhkan 41.552 alumni yang terserap di berbagai lapangan kerja, baik dalam negeri maupun luar negeri, dan mengayomi 23.814 mahasiswa yang kini masih menempuh proses pendidikan di 50 jurusan atau prodi dari 8 fakultas dan pasca sarjana yang ada di UIN Alauddin. Fakultas-fakultas itu adalah Fakultas Syariah dan Hukum,
supaya
Fakultas Tarbiyah dan Keguruan, Fakultas Usuluddin, Filsafat dan Politik,
barik kan.
Fakultas Adab dan Humaniora, Fakultas Dakwah dan Komunikasi, Sains dan Teknologi, Fakultas Kedokteran dan Ilmu Kesehatan, Fakultas Ekonomi dan Bisnis Islam, dan Pasca Sarjana. Untuk mendukung tumbuh kembangnya sumber daya manusia yang dimiliki UIN Alauddin Makassar, pihak universitas melengkapi berbagai sarana penunjang dan fasilitas kampus, gedung kuliah, gedung perkantoran, perpustakaan pusat yang terkoneksi secara online dengan perpustakaan fakultas, rumah jabatan rektor, mes, asrama putra dan putri, kantin dan pertokoan, kafetaria, poliklinik, rumah dinas, masjid, lapangan olahraga, rusunawa Menpera, gedung karakter building, gedung training center, gedung pusat kegiatan mahasiswa, asrama mahasiswa, pesantren Madani, dan pesantren Al-Hidayah Malino. Selain itu, UIN Alauddin kini sedang membangun gedung perkuliahan untuk program pasca sarjana dan pembangunan rumah sakit pendidikan sebagai tindak lanjut dari pengembangan Fakultas Kedokteran yang diresmikan oleh Menteri Agama Republik Indonesia.
Baru-baru ini, UIN Alauddin Makassar mendapat kepercayaan pemerintah melalui Menteri Ristek, Dikti, dan Menteri Agama Republik Indonesia, yakni pemberian izin penyelenggaraan program studi pendidikan dokter dan profesi dokter, program studi perbankan syariah, program studi hukum ekonomi syariah, dan program studi ilmu falak.
UIN Alauddin Makassar juga memiliki lembaga penelitian dan pengabdian kepada masyarakat atau LP2M untuk menunjang kegiatan penelitian dosen dan mahasiswa dan memastikan pelibatan mereka dalam pengabdiannya kepada masyarakat. Lembaga penting lain yang bergerak dalam upaya peningkatan dan penyaminan mutu perguruan tinggi di UIN Alauddin adalah Lembaga Penjaminan Mutu atau LPM sebagai unsur pelaksanaan dalam bidang pembangunan standar mutu, audit mutu, dan pengendalian mutu akademik pada tingkat universitas. Di samping itu, Unit Pelaksana Teknis atau UPT juga ikut melengkapi seluruh unsur penunjang penyelenggara pendidikan yang ada di lingkungan Universitas Islam Negeri Alauddin Makassar. Apresiasi besar juga ditunjukkan oleh berbagai organisasi dan lembaga luar akan pencapaian UIN Alauddin dalam kancah akademik dan dunia pendidikan. Potensi besar ini menarik perhatian sejumlah kalangan dari dalam dan luar negeri untuk turut serta berpartisipasi dan membangun UIN Alauddin menuju cita-cita besarnya sebagai kampus berperadaban dan Center of Excellence. Peningkatan kualitas ini semakin meneguhkan UIN Alauddin Makassar sebagai medium transformasi intelektualisme Islam dalam rumah Indonesia.
Insya Allah, semua ini akan terwujud dan menjadi tonggak sejarah dalam mewujudkan UIN Alauddin sebagai kampus peradaban.
UIN Alauddin Makassar, pencerahan, pencerdasan, dan prestasi.
Ini amanah gue. Lazada Amanah, kebutuhan muslim terpercaya untuk kita semua. Yakin amanah? Lazada.
Good grammar and spelling are important, but if you want to write essays that inspire, messages that forge brighter connections, and emails that get the job done, you need to think about more than just grammar and spelling. This sentence is grammatically correct, but it's wordy and hard to read. It undermines the writer's message, and the word choice is bland. Grammarly's cutting-edge technology helps
Program Studi Ilmu Hukum memiliki visi sebagai pusat riset, pengkajian, dan pengembangan keilmuan hukum yang berperadaban. Untuk mencapai visi tersebut, maka ada 3 misi yang ditempuh atau dilaksanakan oleh program Studi Ilmu Hukum. Yang pertama, menghasilkan sarjana hukum yang memiliki kemampuan menerapkan hukum di tengah-tengah masyarakat. Yang kedua, menghasilkan sarjana hukum yang memiliki kemampuan dalam menjalankan profesinya. Dan yang ketiga, mewujudkan nilai-nilai budaya hukum yang islami. Dalam menjalankan visi dan misi tersebut, Fakultas Syariah dan Hukum, Program Studi Ilmu Hukum, memiliki beberapa sarana dan prasarana. Yang pertama adalah ruangan dosen. Ruangan dosen Fakultas Syariah dan Hukum itu berdiri sendiri di gedung dosen berlantai 3, dan masing-masing dosen Program Studi Ilmu Hukum memiliki ruangan tersendiri. Yang kedua, adanya laboratorium justisi. Dalam laboratorium justisi ini ada beberapa ruangan yang dijadikan sebagai ruangan praktik sidang. Kemudian ada lembaga konsultasi dan bantuan hukum. Lembaga konsultasi dan bantuan hukum ini memberikan jasa bantuan hukum baik secara litigasi dan non-litigasi. Kemudian yang selanjutnya ada namanya klinik hukum. Klinik hukum ini adalah salah satu bagian dari kurikulum ilmu hukum, di mana dalam proses klinik hukum tersebut mahasiswa diharapkan bisa menjalankan profesinya sesuai dengan bidangnya keilmuan masing-masing. Kemudian selain laboratorium justisi juga terdapat ruangan perkuliahan, baik itu ruangan perkuliahan dalam lingkup Fakultas Syariah dan Hukum dan ruangan perkuliahan yang berdiri sendiri dan bergabung dengan beberapa fakultas yang lain atau biasa dikenal dengan istilah gedung terpadu. Kemudian tersedia juga sarana prasarana seperti ruangan lecture, yaitu tempat untuk mahasiswa melakukan semacam perkuliahan dalam jumlah kapasitas yang besar. Kemudian juga tersedia perpustakaan. Di perpustakaan tersebut beberapa referensi buku yang ada, baik itu hukum maupun hukum Islam. Bahkan di program studi ilmu hukum sendiri memiliki mini perpustakaan yang menyiapkan buku-buku hukum sebagai referensi mahasiswa dalam menyusun skripsi.
Akan mendapat pendapat
tentang soal-soal yang akan ditanyakan kepada saya.
Tentang soal-soal yang akan ditanyakan kepada saya.
Sesuai dengan kalian dan ilmu pengetahuan yang sendiri.
Sesuai dengan kalian dan ilmu pengetahuan yang sendiri.
Terdakwa dalam persidangan dan saudara-terdakwa saudara masih dalam status tahanan. Demikian sudah ditetapkan.
Majelis Hakim memasuki ruang persidangan.
Sidang lanjutan perkara pidana dengan nomor register perkara 085.
Dalam hukum, salah satunya adalah pemerintahan berdasarkan peraturan perundang-undangan. Jadi kita sebagai anak hukum harus tahu. Jadi undang-undang yang penting bagi kita undang-undang dasar atau undang-undang terkait pembentukan peraturan perundang-undangan. Itu ada di pasal
Dengan ucapan Bismillahirrahmanirrahim, maka kegiatan ini dibuka dengan
Program Studi Ilmu Hukum memiliki visi sebagai pusat riset, pengkajian, dan pengembangan keilmuan hukum yang berperadaban. Untuk mencapai visi tersebut, maka ada 3 misi yang ditempuh atau dilaksanakan oleh program studi ilmu hukum. Yang pertama, menghasilkan sarjana hukum yang memiliki kemampuan menerapkan hukum di tengah masyarakat. Yang kedua, menghasilkan sarjana hukum yang memiliki kemampuan dalam menjalankan profesinya. Dan yang ketiga, mewujudkan nilai-nilai budaya hukum yang islami. Dalam menjalankan visi dan misi tersebut, Fakultas Syariah dan Hukum, program studi ilmu hukum, memiliki beberapa sarana dan prasarana. Yang pertama adalah ruangan dosen. Ruangan dosen Fakultas Syariah dan Hukum itu berdiri sendiri di gedung dosen berlantai 3, dan masing-masing dosen program studi ilmu hukum memiliki ruangan tersendiri. Yang kedua, adanya laboratorium justisi. Dalam laboratorium justisi ini ada beberapa ruangan yang dijadikan sebagai ruangan praktek sidang. Kemudian ada lembaga konsultasi dan bantuan hukum. Lembaga konsultasi dan bantuan hukum ini memberikan jasa bantuan hukum baik secara litigasi dan non-litigasi. Kemudian yang selanjutnya ada namanya klinik hukum. Klinik hukum ini adalah salah satu bagian dari kurikulum ilmu hukum, di mana dalam proses klinik hukum tersebut mahasiswa diharapkan bisa menjalankan profesinya sesuai dengan bidangnya keilmuan masing-masing. Kemudian selain laboratorium justisi juga terdapat ruangan perkuliahan, baik itu ruangan perkuliahan dalam lingkup Fakultas Syariah dan Hukum dan ruangan perkuliahan yang berdiri sendiri dan bergabung dengan beberapa fakultas yang lain, atau biasa dikenal dengan istilah gedung terpadu. Kemudian tersedia juga sarana prasarana seperti ruangan lecture, yaitu tempat untuk mahasiswa melakukan semacam perkuliahan dalam jumlah kapasitas yang besar. Kemudian juga tersedia perpustakaan. Di perpustakaan tersebut beberapa referensi buku yang ada, baik itu hukum maupun hukum Islam. Bahkan di program studi ilmu hukum sendiri memiliki mini perpustakaan yang menyiapkan buku-buku hukum sebagai referensi mahasiswa dalam menyusun skripsi.
Akan mendapat pendapat
tentang soal-soal yang akan ditanyakan kepada saya.
tentang soal-soal yang akan ditanyakan kepada saya.
Sesuai dengan kalian dan pengetahuan yang sendiri.
Sesuai dengan kalian dan ilmu pengetahuan yang sendiri.
Terdakwa dalam persidangan dan saudara terdakwa saudara masih dalam status tahanan. Demikian sudah ditetapkan.
Majelis Hakim memasuki ruang persidangan.
Sidang lanjutan perkara pidana dengan nomor register perkara 085.
Sidang hukum salah satunya adalah pemerintahan berdasarkan peraturan perundang-undangan. Jadi kita sebagai anak hukum harus tahu. Jadi undang-undang yang penting bagi kita undang-undang dasar atau undang-undang terkait pembentukan peraturan perundang-undangan. Itu ada di pasal
dengan ucapan Bismillahirrahmanirrahim, maka kegiatan ini dibuka dengan
Grammarly does more than catch errors. With Grammarly, you can find really good, no, perfect words that make your writing sharp.
UIN Alauddin Makassar bersatu menuju perubahan, meretas sekta-sekta dan warna yang ada, ilmu hukum mempersatukan kita. Di bawah panji-panji buku timbangan dan palu, menuju hukum progresif, menjunjung tinggi nilai-nilai keadilan, hukum positif dan hukum Islam. Beda warna, beda asa dan beda budaya, tetap teguh dan berjuang dalam satu tujuan. Beda warna, beda asa dan beda budaya, tetap teguh dan berjuang dalam satu tujuan. Ilmu hukum UIN Alauddin Makassar bersatu menuju perubahan, meretas sekta-sekta dan warna yang ada, ilmu hukum mempersatukan kita. Hukum UIN Alauddin Makassar bersatu menuju perubahan, meretas sekta-sekta dan warna yang ada, ilmu hukum mempersatukan kita. Di bawah panji-panji buku timbangan dan palu, menuju hukum progresif, menjunjung tinggi nilai-nilai keadilan, hukum positif dan hukum Islam. Beda warna, beda asa dan beda budaya, tetap teguh dan berjuang dalam satu tujuan. Beda warna, beda asa dan beda budaya, tetap teguh dan berjuang dalam satu tujuan.
Saya Istiqamah ICHR, merupakan ketua jurusan hukum Fakultas Syariah Hukum, mempunyai harapan kepada semua mahasiswa Fakultas Hukum, terkhusus kepada Anda mahasiswa baru Fakultas Hukum, kiranya kelak dapat menjadi calon penegak hukum yang berhak dan juga dapat menjalankan nilai-nilai budaya hukum yang Islam.
Salam. Waalaikumsalam.
Waalaikumsalam, Pak Rektor.
Salam.
Assalamualaikum, Prof.
Waalaikumsalam warahmatullahi wabarakatuh. Ya Pak Hasbi.
Ikut bersih-bersih ya, Prof.
Ya biasa Pak, tiap pagi sebelum masuk kantor, keliling kampus, cek kebersihan, sekalian olahraga, dan bantu-bantu sedikit cleaning service. Supaya mimpi kampus asri bisa terwujud. Kalau kampusnya asri, warga kampusnya hatinya jadi bersih.
Kebetulan, Prof. Bicara tentang bersih ini, apalagi dalam rangka Hari Anti Korupsi Sedunia, bagaimana peran perguruan tinggi untuk menciptakan pemerintahan yang bersih, Prof?
Agak serius ini ya pertanyaannya Pak Hasbi. Saya buka masker dan kita berjarak ya Pak. Menjawabnya, saya kira saya perlu bertanya secara reflektif Pak Hasbi. Apakah kita sadar bahwa perguruan tinggi ikut berkontribusi melahirkan orang yang bermental korup? Apakah kita tahu bahwa perguruan tinggi ikut berperan menciptakan sosok yang mudah tergoda oleh materi, terhenyap oleh rayuan hedonisme hidup? Faktanya Pak Hasbi, mereka yang divonis korupsi hampir semuanya memiliki gelar akademik yang tentunya didapat dari perguruan tinggi. Padahal sejatinya perguruan tinggi itu harus berperan untuk menciptakan good and clean governance. Karena perguruan tinggi adalah benteng terakhir pendidikan formal anak bangsa untuk membuat mereka menjadi sosok yang berintegritas. Memiliki mental yang tidak mudah berkompromi dengan transaksi yang abu-abu. Memiliki mental yang tidak permisif pada cara-cara hidup yang menyimpan dari aturan.
Apa yang harus dilakukan untuk mewujudkan tradisi anti korupsi, Prof?
Setidaknya ada 5 yang harus dilakukan di benak saya, Pak Hasbi. Yang pertama, perguruan tinggi sejatinya mendesain kurikulum anti korupsi. Ya, wujud nyatanya adalah adanya mata kuliah tersendiri tentang integritas atau anti korupsi. Atau bisa juga memasukkan dalam mata kuliah yang sudah ada. Nilai-nilai integritas itu dimasukkan dalam mata kuliah yang relevan. Yang paling penting dalam mata kuliah itu adalah ajaran kearifan lokal atau local genius yang syarat dengan nilai-nilai integritas. Ya, karena anak-anak muda kita sangat mudah memahami ajaran kearifan lokal karena mereka tumbuh dalam tradisi khas mereka. Yang kedua, perlu kita membangun jejaring perguruan tinggi untuk menyebarkan ajaran integritas atau anti korupsi ini. Tidak mungkin kita melakukan sendiri, Pak, atau sendiri-sendiri. Bekerja sama lebih efektif dari sama-sama bekerja. Kita di UIN Alauddin ini sudah punya pengalaman beberapa tahun lalu untuk melakukan proses mainstreaming gerakan anti korupsi ini melalui keaktifan kita pada gerakan Indonesia Integrity Education Network. Hampir 100 jaringan perguruan tinggi di Indonesia. Namun ini menjadi vakum dan tidak aktif, sayang sekali. Dan menurut saya ini yang perlu dihidupkan kembali. Yang ketiga, pembelajaran agama harus kuat. UIN memiliki basis yang kuat dalam pembelajaran agama. Termasuk penguatan atau reformulasi doktrin keberagamaan. Kenapa doktrin? Karena doktrin itu mempengaruhi alam sadar anak-anak kita dari kecil. Contohnya Pak, doktrin eskatologis tentang surga. Dari kecil kita diajar, orang tua kita, guru mengaji kita, pelajaran agama kita. Orang yang rajin sholat masuk surga. Nah ini harus diperkaya dan direformulasi. Ini yang harus diinovasi, ditambahkan. Orang yang jujur pasti masuk surga. Artinya Pak, gong kejujuran itu harus selalu ditabuk, digaungkan. Supaya ehonya bisa kedengaran di tengah-tengah masyarakat. Yang tidak kalah pentingnya adalah yang keempat. Harus ada role model orang jujur. Supaya cerita orang jujur itu bukan mitos. Tidak fiktif, faktual, nyata adanya. Bukan sekedar cerita legenda pengantar tidur bagi anak-anak kita. Pak Hasbi, di Makassar ini negerinya orang yang berani jujur. Di sini Pak, pernah hidup sosok yang bernama Baharudin Lopa. Semua anak negeri pasti paham sosok ini. Sosok yang berintegritas, yang tidak pernah mau menerima hadiah sedikit pun yang terkait dengan jabatannya. Di kampung halaman saya di Bone, yang jauh di sana, ada seseorang yang bernama Ustadz Fatur Rahman. Seorang PNS, dosen, mengajar di IAIN Bone. Sosok ini dikenal oleh warga di mana dia hidup dan bergaul sebagai sosok yang tidak pernah berbohong sekalipun. Dan yang terakhir, yang kelima ini menurut saya sangat penting juga. Orang jujur harus dibuat lebih mujur. Ekonominya tidak susah, aksesnya tidak terbatas, karirnya tidak terhambat. Anak-anak muda yang memiliki skill membuat sistem transparan misalnya, harus diberi ruang untuk beraktualisasi, Pak. Bukan diberi sertifikat kejujuran, tetapi diberi fasilitas untuk mempermudah hidupnya dengan apresiasi atas nilai aktualisasinya. Itulah 5 hal menurut saya yang perlu menjadi terobosan atau breakthrough dari perguruan tinggi sekarang ini, Pak.
Terus bagaimana memulainya tuh, Prof?
Bagaimana memulainya? Jawaban saya singkat, Pak Hasbi. Disinilah tempatnya dan sekarang waktunya. UIN Alauddin ini bukanlah deretan gedung-gedung, bukanlah rimbunan pepohonan, Pak. Bukan hamparan tanah lapang yang berlokasi di Goa dan di Makassar. Tapi UIN Alauddin adalah komitmen kita bersama untuk melahirkan generasi masa depan bangsa dengan keunggulan karakter dan jati diri. Saya kira itu ya, Pak Hasbi.
Ya, terima kasih wawasannya Pak Rektor.
Sama-sama Pak Hasbi, silakan lanjut. Saya juga lanjut sedikit. Waalaikumsalam warahmatullahi wabarakatuh. Pak Hasbi, satu lagi.
Iya, Prof.
Tahu kepanjangannya korupsi?
Apa itu, Prof?
Korbankan rakyat untuk kepentingan diri sendiri.
Betul juga ya, Prof. Mari, Prof.
Ya. Assalamualaikum warahmatullahi wabarakatuh. Semangat pagi. Saya Hamdan Juhanis, Rektor UIN Alauddin Makassar. Pagi ini saya berada di jogging track di kampus 2 UIN Alauddin di Samata, Goa. Seperti yang kita saksikan, banyak teman-teman setiap Jumat ramai mengisi waktunya untuk melakukan kegiatan jogging di jogging track Win Alauddin Makassar. Ini adalah salah satu fasilitas olahraga yang kita miliki yang diperbaharui dengan lapangan bola yang ada di tengah, pemandangan kampus-kampus di sekitar. Dan di sebelah sana ada gazebo. Ya teman-teman kalau sudah berolahraga bisa ngerumpi sejenak sambil menjaga protokol kesehatan. Jadi saya meminta semua teman-teman, ya sahabat-sahabat semua yang mengikuti jogging track harus memastikan untuk menjaga protokol kesehatan secara ketat, memakai masker, menjaga jarak, dan setelah itu kembali ke tempat masing-masing, ke ruangan masing-masing untuk beraktivitas, tentunya dengan mencuci tangan. Jadi saya mengajak para warga yang sempat ada di Makassar atau mengunjungi Makassar, boleh jalan-jalan ke kampus kami, Kampus Peradaban UIN Alauddin Makassar, dan bisa kita jogging sama-sama di pagi hari. Saya kira itu, terima kasih. Semangat pagi, pagi, pagi. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Mulai, saya bicara dulu tuh. Sedikit bicara. Iya. Baru kalau ada 10 menit, ya ada waktu untuk bisa dibagi? Ya. Bisa bagi? Bisa dibagi ke backup? Iya. Kita sampai tadi. Batang sampai tadi. Tapi kasih dulu kan? Oke. Iya.
Ini anggaran dia jangan di report lagi.
Iya, ini jadi
karena kalau di report di lama sekali. Kami perlu di ini lama itu di dalam. Iya, kami di dalam.
Jangan.
Jadi kalau di report nanti di report semua yang terus
Halo, tes. Ya, Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, the participants, I would like to inform that in 10 minutes, we would like to begin the parallel session. But before we start, I will inform some information. First, the committee will divide the participants in several breakout rooms. Based on your room, we have give you the room 1 until room 4. So just be prepared. We will begin in 1 o'clock p.m. Okay. So let me the committee interview into the breakout room. Thank you. Panitia akan memasukkan peserta ke dalam ruangannya, ruangan breakout roomnya, ruangan kecilnya, mulai dari ruangan 1, 2, 3, dan 4. Harap para peserta bersiap-siap sesuai waktunya. Kemudian ya kami akan memulai memasukkan peserta, jadi peserta tinggal masuk saja dan siapkan diri untuk presentasi. Terima kasih.